It's also attached to the email.
Yeah.
Okay, we're
I'm
there.
asking if that was the final.
The one
You didn't
attached to
make
the
it.
invite. No, we didn't. There was some typos in the ones that I added of the really I have seen it.
But I mute.
Mr. Matebula.
Good morning, sir. How are you?
I'm very well, sir. How are you?
Good, man. I'm good.
Yes.
I can hear you.
Sorry?
No, it's fine. You are clear.
Okay. Now I wanted to check if you are going to be sharing your presentation from this account so that I give it permission.
Yeah.
Or maybe suggest that we do it here.
From this account. Okay, cool.
Yeah, either maybe what you can do, you can probably put it to the advocate van Schoors. Yeah.
Is she going to join from a separate account?
No, I'm gonna join from my account. I'll just join into the meeting now.
Okay, advocate.
Yeah, I'm also gonna see if I can link, because in an email I think we did indicate that at least you can make the two of us co-hosts to you. No?
Okay,
You must also have it in case that we experience some hiccups.
Okay, I will be on standby.
Yes. Okay, Mr. Mungwen, thanks.
Recording in progress.
Welcome, everybody. It's 10 o'clock, especially to the stakeholders who are here, also National Treasury, obviously. In Kuleko, have we got any apologies?
Morning, Chair. From the side of members, I've got an apology from Mr. Muletsane. He will join late. From the side of stakeholders, it's only Corruption Watch, Chair.
Who have apologized?
Yes, Chair.
So the others are all here?
Yes.
Okay.
Chair.
All right. Just to remind colleagues and comrades and also stakeholders and Treasury, this is a continuation of the public hearings. Treasury will tell us at the moment. They sent their report on Monday. Between the 8th and 10th, they met most of the stakeholders who chose to engage with them. And this is the tail end, if you like, of the consultation process. Following this process, we will then move into committee stage and deal with the bill. Can I hand over to you, Treasury? You can take 45 minutes to an hour. There's an apology from somebody in the chat. There's a Professor Gio of APU who is unable to attend due to a scheduling conflict. Okay, we'll note that. Can we move on, Willie and your team? An MP, I think, is here.
Thank you, Chair. Good morning.
Before we move on, can I just raise one thing in case people misunderstand? I don't know that it's necessary to say this, but perhaps in case. You went off and you consulted and you arrived at consensus on some issues. You remain at variance on other issues. And yet other issues we're not sure whether you agree or disagree. So it doesn't follow, obviously, that the committee, if you arrived at consensus, the committee will necessarily agree. We will take very seriously into account that you have arrived at consensus. What's the point of asking you to engage unless we're going to take it seriously, right? There are times where you might disagree and we will say, fine, let's leave this out of the bill. Or we might say, no, we disagree with your disagreements and we're going ahead, and so on. As long as it's understood that ultimately it's elected politicians in a democracy that make the final decisions, and so it will be with us. So to the extent we're drawing in stakeholders today, we're urging that you engage in a give and take manner, because we're not going to sit here endlessly. We've gone through this process. We've been with this bill since 2014. It went through NEDLAC. There was the NA process. There's been our public hearings. We heard you, stakeholders, and then we got Treasury to reply, and then you replied. Then we said, okay, go off and see where you can find yourselves. And over 3 days, Treasury did that. We thank you for participating in that process. We thank Treasury for organizing it. But whatever it is that you agree or disagree on, ultimately Parliament must decide. The other thing to say is that we must take us through the constitutional issues, and there are many of them. But you see, we are not professors of law. We are not senior counsel. If the constitutional law advisors said the bill is legally and constitutionally sound, if National Treasury's lawyers say so, and if our own legal services unit say so, we are not a forum for, like, intellectual debate on fine technical issues of the law. We don't have the skills. So please, understand that if the experts, and particularly our expert, Frank Jenkins and his team in the legal services unit of Parliament, whatever the executive says, whatever stakeholders say, ultimately Parliament must say, okay, we've heard everybody. So Frank, you have a very crucial role to play on the constitutional side, right? We will hear the finer details today, but we're not going to spend hours and hours understanding each particular clause and its constitutional meaning. As long as the legal services unit says it's fine, and we're going to give you from today till Monday, we will have to go by that. Ultimately, these disputes can only be settled by the Constitutional Court. And if the bill has to go to the court, fine. The court will arbitrate and decide. And there'll be a new committee in the new term, and they will then make the adjustments that are necessary, because the courts ultimately prevail over Parliament on constitutional issues. So I need to say this because I must say I found it quite difficult, Willie, MPU, the lawyer, working out exactly what would be the correct answer to some of these issues. I certainly don't have the skills. I don't think any member of this committee has got a legal background, and we don't need to have that. So, ultimately, I think this matter can be taken to the courts if people so decide. Okay, having said that, I've read it twice, Willie. That's all I'm saying. I've been in Parliament for 30 years. I have a reasonable background in education. I'm telling you, Willie, it's hard for me to follow. I read a thing last night, and this morning I asked you for the Word version so I can organize my thoughts, and I've been at it. But I can tell you, I don't have the expertise, constitutional expertise. Right. Having said that, over then to you guys. Willie, an MP, and there's a third person there. What's her name? Will she introduce herself? I don't think we met her before.
Yeah.
Who will she be?
Yeah. Good morning, Chair, and then the honorable members of the committee and the stakeholders as well. Chair, you've already outlined the process.
Willie, hang on. There's a third human being there, right? Who would she be?
Okay.
She's appearing before the committee. Yeah. She can speak for herself, can't she, Willie?
Yes, you can speak for herself.
Okay,
Yes.
well, who is she? We want to know. We haven't seen the person before. And she's appearing before the committee. Even if she doesn't say a word, she's appearing before the committee. She's using our taxpayers' money while she's here. So she's accounting to Parliament. Who would you be, madam?
Good morning, Chairperson and honourable members and colleagues on the platform. Chair, I am Shirili Missa, and I'm the Director Legislative Services in National Treasury.
All right, so you're a lawyer.
Yes, sir.
Good. And you're allowed to speak as well. I know Willie's your boss. I don't know whether he's a tyrant or what, but as far as we're concerned, you're all being paid by the state, and you must all participate. What's the point of sitting like a lemon there? Okay, let's go on.
Thank you, Chair. Thank you.
From this person, yeah.
Yeah, thank you, Chair. And then I will then allow Chair, because we've already outlined the background and so on, where we're coming from and where we are and where we're going to. So without taking much time, I'm going to allow my colleague, Advocate Manscoor, just to run through the presentation. It's a 38-slide presentation, but what we did, Chair, we're going to run through the issues. We've just picked up from the report what we believe are key issues that, of course, we need to share with the committee. And that's what the presentation is all about. Otherwise, if we had taken the entire report, and we would be having 100 slides and so on. So if there are any other issues, we would, of course, implore at least the committee to refer to the report that the Chair has referred to already. Thank you, Chair. With those words, may I then allow Advocate Manscoor to take us through the presentation. Thank you.
Good morning, Chairperson and other members.
Yeah,
of
but
the
don't
committee.
rush it. You can have up to an hour. You know why? It's quite a complex bill, right? And we've got time. So, especially now that we're not having plenary sittings. So don't rush it. But after 45 minutes to hour, people's interest wanes, concentration. But go ahead, please.
Good morning, Chairperson, other members of the committee, stakeholders, and the parliamentary staff and colleagues from Treasury on the platform. I'm firstly going to start with the Joint Strategic Resource Group that we met and the constitutional issues that they raised. And as indicated by Mr. Matebula, this is it's not everything that was said, but we try to make a summary in the presentation. The first, one of the points I made is that tenders must be evaluated in a manner that gives effect to the purposes of 217 of the Constitution. Sorry. I'm just trying to avoid the pop-ups in front of the concern I raised is that Chapter 4, dealing with preferential procurement, presses little reason to believe this is how tenders will be evaluated. And that valid concerns that the bill will unleash disruptive constitutional litigation. Now, a further constitutional question that I argue is that it's still open if you consider Treasury's response is a continuing gap in clearly locating the power to develop preferential procurement policies. And then referring to Treasury's reliance on the Butler's opinion, which asserts the distinction between the terms develop and implement. Now, 2172 of the Constitution, when it deals with preferential procurement policies, specifically use the word implement the procurement preferential policy. And then they reiterated that they've raised the concern that although it's often gestured in this direction, that nowhere clearly it assigns the power to develop preferential procurement policies to procuring institutions. Now, in our response, which I, as a solution to this issue, we proposed that in clause 16, which is the first provision in Chapter 4, that we insert the provisions of the term develop and implement. Implement's already there, and that will mean that procuring institutions will develop and implement their procurement policies. And then also to make it clear that when they determine these policies, apart from complying with Chapter 4 of the bill, they must also comply with the regulations made under the Act, that phrase be added in clause 16. And then on the same basis, clauses 8 and 25 that deals with the procurement system and also the procurement policy, I'm going to call it the general procurement policy, that we similarly indicate that that this will be developed and implemented by the procuring institution. And in those instances where the term this act is used, it does include the regulations and instructions. Then the JSR also proposed a virtual workshop to be held, a one-day workshop on the topic of constitutional principles and the public procurement bill as soon as possible. Sorry, Chair, the slides doesn't want to move. Thank you. Then another matter raised by the JSR is incentivizing whistleblowing, referring to the tradition of incentivize whistleblowing, which is in legislation dealing with specific sectoral matters, and they're referring to the environmental legislation. And then also because procurement handles a large sum of money, which means that whistleblowing in this area can be incentivized without cost to state. And therefore, it could be tailor-made for procurement operations. And the other concern that I raised is that the Protected Disclosures Act only applies to employees, but in procurement, incentivized whistleblowing is often for persons who are not employees. Now, in Treasury's response, which we indicated earlier on the comment matrix, is that that enhancement of whistleblower legislation, in particular the Protected Disclosures Act, is a matter to be attended to by the Justice Department. And as we indicated, they already published a discussion paper in 2003, and they're busy finalizing draft legislation and following considering the comments received on the paper. I'm sorry. Then the next group that we met with is the Procurement Reform Working Group, consisting of a number of stakeholders. Now, the first concern that I raised is that if you consider Chapter 4, the new Chapter 4, it restricts participation in procurement from the outset. Also that it confuses leading procurement experts as to how the rules it seeks to establish will be implemented in practice. And it also does not lay down any objective and measurable criteria for adjudication. And then it does not require restrictions on competition and the justification for that. And it opens the way for anti-competitive practices. And then also further concern is that it doesn't mention price, which is highly unusual internationally. I think our main response is that the regulations will detail how the framework must be implemented. And then a proposal that we make that in clause 25 that deals with all procurement matters and will also apply in the case of Chapter 4, that we provide that the framework that the minister must prescribe contains a requirement on bid evaluation as part of the framework for that the institution must implement, and that should include matters like where applicable functionality and price and so on. Then further concern raised by this working group is the alignment of Chapter 4 with the rest of the bill. And the argument is that the bill establishes two frameworks, one in Chapter 4 and another one in Chapter 5, with overlapping subject matter. And also a concern raised that Chapter 4 contains procedural steps. Now, firstly, our view is that 2173 of the Constitution requires a framework for preferential procurement. So there's no choice that Parliament has to prescribe such a framework. And then also it's the object of the bill to outline the broader general procurement framework for purposes of 217. And this is provided for in clause 25 of the bill. Then the concern about procedural steps being contained in Chapter 4, we propose that section 518 to C, which are, I think other stakeholders also raised this, that this should be omitted, and it will be covered through an enabling provision in what I just mentioned in clause 25, if accepted. And then also there's a number of references in Chapter 4 to complementary goals, and our proposal is that this should be omitted. Then institutions must apply preferential procurement as provided for in Chapter 4 within its procurement system, developed and implemented as determined by regulation under Chapter 5, read with clause 8 of the bill. So in our view, that the framework for preferential procurement and the one which the procurement system set by the minister in regulations, that there is no challenge in overlapping mandates, especially now that we also removed the procedural steps from Chapter 4. Now, as to the powers of, this is a concern raised also by the stakeholders of the Public Procurement Office and Provincial Treasuries to review procurement policies of procuring institutions. This was in the bill that was tabled in Parliament last year. And their view is that they see this as a basic function of a strong, regulated and created procurement regime, and believe that these powers should be reintroduced. Our view is that the provision that's in the bill that's before the committee, that the Public Procurement Office may issue a model policy which a procuring institution may customize according to its own institutional requirements, suffice in this regard. And this is also aligned to the decision-making powers of accounting officers and authorities in Clause 7 of the bill, so that they make decisions on procurement, and therefore they should determine their own policies. But there would be this model policy once developed, and there may be different policies for different kinds of procurement. If it's in place, then institutions can customize it for their own requirements. Another issue raised by this working group is the independence of the Procurement Office, and that it should be, sorry, this is actually our response to this issue that was raised. And we still have the view that the need for this office to be independent is not clear. The role of the Procurement Office is regarding government's requirements for goods and services, which can't be provided in-house, and therefore it's not regulating procurement in the private sector from another private sector company. The bill also does not make the Procurement Office the chief buyer on behalf of government. Procurement by institutions will be done by institutions within the framework set by the Act and the regulations and instructions. Then a further argument that we are making is that 2162 of the Constitution requires that National Treasury must enforce compliance with, among others, uniform norms and standards regarding transparency and expenditure control. Now, if you consider literature, expenditure control includes procurement, and this could be determined in both in primary and subordinate legislation. Because of the definition of national legislation 213 of the Constitution, which says it includes subordinate legislation. Therefore, in our view, having the Procurement Office in National Treasury accords with Section 2172 of the Constitution. Another area of concern is beneficial ownership. It's essentially the bill that's before the committee. More than one stakeholder raised the issue that it refers to the incorrect provision in the Companies Act, and it should refer to Section 56(4) of the Companies Act. And there's, apart from the reference, there's also terminology like register that we have to introduce. So we propose that this amendment be made to Clause 33 that deals with the disclosure of information. And this is in the context of what information a procuring institution must make known when an award is made. And it's required that the beneficial ownership of the successful bidder should be disclosed. So we do support this concern, or address this concern by stakeholders by proposing this amendment. Another concern raised by the working group is in the context of the definition of confidentiality or confidential information in Clause 1 of the bill. Because currently the bill, in respect of personal information, it refers to the Protected of Personal Information Act, and then it has a list of other grounds or areas that's considered to be confidential. So the proposal firstly was not to refer to POPIA, because that is the argument that is not the purpose of that bill is to constrain the release of personal information, and it's too broad. That in the interest of transparency, we should refer to the promotion of access to information, which has a definition of personal information. But there was an alternative proposal made by this working group and also by Consultation and SACTU, which indicated instead of just relying to the Quality Per Year Act just for personal information, that we use per year as the basis for all references to or the protection of confidential information. And we do support that, so we will propose an amendment for consideration that confidential information would be essentially be those information that may be refused or must or may be refused in terms of the Per Year Act. Then another issue raised by the working group is about there's a number of proposed amendments to Chapter 4. And again, this is similar to what Consultation and SACTU have proposed. We didn't list all the proposed amendments, but just in short, the ones that we do support. First of all, which I mentioned earlier, is that we propose that the references to complementary goals be removed from Chapter 4 in all those mentioned sections. We also, the proposal made by the work group is that in clause 18.1, where we deal with pre-qualification, that we add the reference to prescribed thresholds and conditions must include a prescribed minimum of potentially qualifying suppliers to ensure competition. So this include part is what we propose to include. Then we also support the omission of clause 21, because we did raise in our comment matrix that we think this provision is too wide, and considering the entire Chapter 4, we in our view, there's no need for this provision. And then I also mentioned earlier that in clause 17.5 that deals with set-asides, we propose and align to what the stakeholders indicated, that we remove provisions that deal with procedural matters, and this is in a bit of litigation according to functionality and so on, and that be removed, and that it simply provides that a bid set aside in terms of this subsection must be evaluated in terms of the prescribed criteria. Then the next stakeholder, PSOM, they raised concerns about the transparency provisions in the bill. Firstly, they expressed their appreciation for the clauses mentioned dealing with transparency. Then one of the concerns they raised is that the minister must prescribe the disclosure requirements via regulations in terms of Section 33, and then under Section 4 details the obligations of the minister when making regulations. Which they support as an improvement to the earlier bill. And then also, because it was in the earlier bill, it was the Procurement Office that had to issue instructions, and it's now proposed that it must be regulations by the minister, which they argue that there's better likelihood of complying with it. But then on the specific comments that they proposed amendments made by PSOM is in relation to the mentioned clauses. So they argue that instead of providing that the minister must prescribe disclosure requirements, the disclosure measures should be fully contained in the bill. And they say that currently there is inadequate access to procurement information. Then in clause 33.1 that deals with the use of ICT by procuring institutions, it contains a term to the extent possible. So I propose that be removed. And then also there's a requirement in 31.2 that regarding the dissertation or the use of technology and so on, that be determined by instruction by the PBO. And then I also propose that we include a provision to align with the national ECT and e-governance strategy. And then also proposals to add to the list information that should be disclosed under clause 33. Now, I would suppose the responses are as follows. In our view, clause 33 that obliges, it's not discretion for the minister to make regulations regarding the disclosure of procurement information listed in that provision. And that this would suffice. And there's also a rigorous process in developing these regulations that will enable transparency. To spell out the details of all of these in the bill, in our view, is not practical. But we believe that indicating that the minister must make such regulations will suffice. Then it's also unlike the current system where transparency provisions in procurement, especially for institutions under PFMA, are largely regulated by the use of instructions. The difference now would be when the bill is enacted together with the regulations will provide for compulsory measures of transparency in primary and subordinate legislation and not in instructions. Then as to the removal of the term extent in the context of using ICT in procurement, now in our view, some institutions, smaller or under-resourced institutions may not be able to do so, and only at a later stage. So at this stage, we do propose that term be retained. Then clause 33 contains a list of information that the minister must regulate. To enable adoption over time, it's submitted that disclosures should be determined by regulations. Now, as to the date when such information should be made available, I think the proposal was that instead of as quickly as possible, it should stipulate a period, but we do think it's necessary to not stipulate a particular period, because it not would be practical to indicate a specific time period. Then there's also to be noted that 33(2)(b) Roman II provides for information to be tracked to track the relevant entire process of specific procurement, which in our view suffices. Then the proposed amendments that we are suggesting is that the requirement in section 31(2)(b) be replaced, because currently say by instruction, we say rather by notice and represent, so it may be easily adapted to prevailing ICT developments. That 31(2)(a) be amended to provide that the PBO must ensure that the notice accords with the national e-strategy envisaged in the ECT Act, and also e-government for the public service as envisaged in the Public Service Act. Then one of the proposed additions from PSAM is that we include bid cancellation information in clause 33, and we support such an amendment. Then the NRF raised an issue regarding funding and the unfunded mandate. Now, their concern is that the CIA's report is inadequate and naive in characterizing fallacious premises, and that no costing is provided, and that relevant organ states must be consulted regarding cost implications, and raising the concern about the contravention of Section 35 of the PFMA. Now, Section 35 of the PFMA requires that if a bill has financial implications for provincial government, then the memo attached to the bill when tabled must indicate such implications. And then in addition, there is a concern currently about VAT deregistration, which is a current issue not pertaining to the bill. Now, in our response, I think firstly to note what I indicated, what the PFMA requires. And our view is that the draft legislation doesn't assign additional functions and powers or impose obligations on a provincial government. And yeah, sorry that I'm just repeating now what the sections say. Just to in more broadly or in particular, sorry, respond to the issues on the fund and the funding. The elements of the procurement system that's in clause 25 are existing elements, which may have to be made part of the procurement system. As to expanding the scope of procurement function in a procuring institution, most of these are not new functions for institutions, but are elevated to prime legislation. And then the enforcement function for provincial treasuries is not new. It's currently provided for in respect of provincial departments in section 18 of the PFMA. And then we did propose in the comment matrix that was submitted in March that the enforcement role for provincial treasury in respect of municipalities be removed in view of constitutional issues raised. Then there's provision for in clause 27 for investigations to be to take place in respect of allegations of irregularities. And again, these are not new functions. It's currently provided for both in the PFMA and the MFMA and the respective prescripts of those acts. Now, as to the cost of regulations and instructions, I think it will be impossible for us to say currently what would it be, but that will be an important consideration when we consult on the development of regulations and instructions. Then important to note also that clause 68 of the bill provides that the provisions of the Act may be brought into operation on different dates and on different dates for different categories of institutions and also different categories of procurement. So where applicable, the availability of funds will be considered in determining the effective date of provisions when we advise the President on bringing the provisions of the Act into operation. Now, the cost of the tribunal, which we do acknowledge should have been mentioned in the memorandum to the bill that was tabled. Obviously, that will be carried through appropriations from the National Revenue Fund to be made to the vote of National Treasury if the PBO is located in National Treasury. And this will have to occur through the normal budget processes once we have determined the estimated cost. And then accordingly, when the tribunal is ready, the relevant provisions will be brought into operation. Another issue raised by the NRF relates to capacity building and emphasizing the importance of getting the basics of procurement right. And this is holding back service and infrastructure delivery in light of the failure of capacity development for procurement of complex and or procurement of innovation. And the NRF is asking that the National Treasury take ownership of capacity building. And then the list of matters that it should provide for. Now, in our view, clause 5.1 provides for the procurement office to guide and support officials and procuring institutions to ensure compliance with the Act through ensuring professional development and the training of officials involved in procurement. And then also relevant institutions will be responsible for its sector and specific capacity building in those areas. Now, the NRF, in relation to innovation, refers to the constitutional authority in 2172A, and that would allow for the promotion of the referring to the USA example of what they call an other transaction authority, and that would be permitted by 2172A of the Constitution, and that we should provide for or propose amendments to remove impediments to innovation in the bill. Just firstly, in response, innovation is recognized in the objects clause, and also in clause 23, which specifically enables institutions subject to preset conditions when procuring to provide for measures to advance innovation. And then Innovation will also be enabled through unlisted bid as one of the procurement methods to be prescribed. Not mentioned here, but in the report, we did propose that we will consider looking at the definition of bid, because the NRF raised the concern that the current text would prevent innovation and also specific maybe unsolicited bids. So we will propose an amendment to the committee. Then the NRF also raised a concern about the provision in the bill in clause 26 about procuring from another organ of state. And the view is held that this is unconstitutional. Now, that there's arguments stated why it's considered to be unconstitutional and it should be removed. Now, our view is that procuring from another institution should be regulated, because there are specific institutions in government that are set up to serve a purpose, a specific purpose for organs of state. And then before such procurement is engaged, and then organs of state should be considered within the parameters provided for in the regulations. Just to mention a few of these institutions that are currently provided services within government is the National School of Government, the Government Printing Works, the Government Technical Advisory Centre, or GTAC, and Council for Scientific Industrial Research. And then also to mention that currently provision for not complying with normal procurement procedures is already provided for in the MFMA in section 110, where a municipality may contract with another organ of state. So in our view, clause 26 should be retained so that this kind of provision of services by another organ of state be properly regulated, and also to ensure that such services are provided in a cost-effective manner. Then on independence of the PBO, I've dealt with this issue earlier in this presentation, so I'm not going to repeat that. Then the submission from Willpower, Mr. Sean Scott. Now, he firstly raised a concern about why is the application of the bill limited to Parliament and provincial legislatures and not the rest of the Act, and that this will continue a fragmentation of the procurement system. Just in brief, the reason why we proposed in clause 3 of that only chapter 4 and the related provisions regarding preferential procurement be applicable to legislatures is that currently the PFMA, applies to legislatures, and if that's removed, then there would be no preferential procurement framework for the legislatures. And then some years back, in around 2008, 2009, Parliament and provincial legislatures were removed from the Public Finance Management Act in view of their constitutional status, and the Financial Management of Parliament and Provincial Legislators Act was passed at the time, and it deals with supply chain management. This particular question, we did ask Advocate Jenkins to advise on his view in this regard, whether the bill could be extended to the entire bill to Parliament and provincial legislatures. And the next slide continues with this issue. Then another issue raised by Willpower relates to donor funding. The proposal or the concern raised is that currently the bill provides that donor funding must adhere to the Act unless exempted under section 60, clause 62 of the bill. Now, multiple parties have said that there's a financial impact risk on provinces and municipalities as international donors may not opt to adhere to the Treasury requirements, and that requesting an exemption may result in delays. And then referring to Treasury's response. Our response to this matter is that our view is that donor funding, the use of donor funding in procurement should be subject to the bill. And as already mentioned, there is a provision for exemption, so it should be 6.2 and not 6.1 in the bill. And then in addition, clause 64 provides the regulations must be made regarding procurement funded partially and full by donor or grant funding. So there is provision to regulate this aspect in the bill. Sorry, Chair. And then an issue raised by also by Willpower is the use of complementary goals. And as indicated earlier, we do propose that this be removed from the bill. And then they also similarly raise a concern about 17.5 dealing with procedural matters, and as indicated, we propose that it be removed. Then on the issue of premiums, Willpower recommends that the framework for setting parameters for premiums must be included in the bill, which may include minimum and maximum determinations and calculation methods. And then they also request that the draft regulations must be available alongside the bill in order to quantify the premium and then engage meaningfully on the cost implications of the bill. And then they refer to our response in the earlier in the comment matrix submitted in March. And they again raised the issue about unfunded mandates in the context of premiums. Now, our response is again, given the rigorous process for making regulations in clause 62, this is a matter that should be considered at that point, and given the number of regulations to be made for Chapter 4 and even in relation to premiums, that this will be a subject matter of consultation in terms of clause 64. Then briefly, Willpower will raise a concern about the procurement system in the list of what it should entail. It also includes asset management. And they will, it shouldn't be part of it. Now, we do support that it be amended to remove asset management from the provisions. Then on contract management, our view, it's again raised that it shouldn't be included. Now, our view, sorry, I'm just trying to move that contract management should remain part because it's a critical element and it's something that it's been acknowledged that it was not properly performed. But we do acknowledge that it may be performed not necessarily in your supply chain unit. They may do parts of simple contracts, but more complex contract may be done elsewhere. And to this end, I think it's an important amendment that we made about concerns, also I think raised by the NRF, as that we don't prescribe where an institution must implement the different aspects that's listed in clause 28. So we proposed to remove the reference to the establishment of a procurement function in the institution. But we simply say that the procuring institution must ensure that the following aspects are actually being performed by the institution. And then it could be decided which unit in the institution will perform those functions. Then in relation to the tribunal, now the tribunal panels, it's provided for in the bill, specifically in clause 47, but the argument was that we shouldn't simply, as we propose in the comment matrix, provides that it should provide for a provincial presence for these panels. And so we do support the proposal that in clause 47, the bill itself provides that there must be panels in the provinces to hear review applications. Then there's a provision in a bill that deals with standstill while a review is underway. And they raise concerns about whether emergencies will sufficiently deal with it, and there's a risk of losing grant and donor funding, and a list of concerns in this regard. Now, firstly, we to what we indicated earlier, there is exemption for donor and grant funding, which the Mason-made grant would justify. And then there's also regulations on to be made on grant and donor funding. And the proposals made by Willpower, in our view, are not practical and will expose the state to fruitless and wasteful expenditure and possibly unnecessary litigation. Now, Summit, they emphasize the fact that these unique medical devices, and there's a requirement to nuance that. Now, and then they were concerned about the fact that we will have a one-size-fits-all procurement system. Now, just to indicate again, which was early in the presentation, that the bill in clause 64 provides for different regulations for different categories of procurement and different categories of procuring institutions. So it's not foreseen that there will be one single set dealing with all types of procurement. There may be general requirements, but specific regulations can be made, for instance, for procuring medical devices or similar devices. Then on the issue of subcontracting, concerns was raised about this, that you can only be licensed as one of three types of companies, and manufacturer, distributor, and wholesaler, and that each type of company has a certain quality management system and regulating system specific to activities and types of products, and has to list its products with SAPRA. Now, in clause 19 of chapter 4, where it deals with subcontracting as a preference tool, it stipulates where feasible, and in our view that addresses the concern. And so in many instances, subcontracting would probably not be applicable in the case of the procurement of medical devices. Now, another concern is raised in relation to again about the procurement of medical devices, about the concept of value-based procurement and specification, that it gives the impression that procurement would cater for nuances and provide for some safeguard for ensuring fit for purpose of procurement. I think it's the same issue. Our view that clause 64 enables different regulations for different categories of procurement and procuring institutions. So, for instance, if it's procurement for a health department or for the NHI. Now, coming to the NHI bill, the NHI bill proposes a procurement system which runs parallel to the procurement bill. That's the input from Summit. And that it proposes centralized procurement system, which in Summit's view does not sufficiently cater for the nuances required in the procurement of medical devices. Now, if you look at the NHI bill, in clause 38, it provides that the health product procurement unit, which is located within the NHI fund, which is proposed to be a public entity, it stipulates in that clause that the provisions of this section are subject to public procurement laws and the policies of the Republic that give effect to Section 217 of the Constitution, including the Triple PFA, which is currently still applicable, and the BEE Act. Now, also in the NHI bill, as I mentioned, it proposed that the fund will be a public entity, and that would mean that the public procurement bill as currently proposed, will apply to the NHI fund when it procures. Now, in clause 3 of the NHI bill, also has a trumping clause in states where there's conflict between the NHI Act and provisions of other law, except the Constitution and the PFMA, or any act expressly amending the Act, the NHI Act will prevail. Now, since the NHI Act has not been signed into law, we can't propose amendments to the NHI bill at this point. But there is a stated interpretation rule that a later act trumps an earlier act, and as it stands, since the bill is the NHI bill is by presence it is assent, it's likely that the NHI bill will be law before the procurement bill. But I think our point, if you consider clause 38 of the NHI bill, there would not be conflict between the two pieces of legislation if once they both on the statute book, because the NHI bill does recognize the procurement laws and state that the procurement will be subject to it. The procurement will just occur in different places by different institutions as currently provided in the case of the health sector, where the NHI fund would have a particular procurement function, but it will be bound by the Public Procurement Act once it's law. Now coming to the comment from the Black Business Council. Now, the Black Business Council proposed that in clause 17, which is set aside, clause 18 pre-qualification criteria, and clause 19 dealing with subcontracting as a preference method, that all categories that are not Black people or owned by Black people be removed. And then, so it's clause 18, not clause 8, and that small enterprises in a geographical area be retained. Now, our view is that the removal of women, people with disabilities, youth and small enterprises and cooperatives, which is not Black owned or Black owned, is not supported, but obviously this is a matter to be discussed further in the committee. The category of preference referred to in these provisions accords with 2172A, which is an open category for preference, and B, 2172B is the category that deals with previously disadvantaged by unfair discrimination. Now, in 2172A, as I indicated, allows generally for categories of preference in the allocation of contracts, so it permits Parliament to pass legislation, for instance, to give preference to the youth or small enterprises, for example, and not necessarily qualified by persons who are Black or Black owned. Now, to move to the submission from BUSA, now they firstly stated they're not satisfied by Treasury's responses. That was now in relation to the comment matrix we submitted in May, and that they, especially where we have made similar comment as those in relation to that Labour SATU made. Now, we just want to reiterate, we did in a comment matrix, comments or responses would be repeated if it's the same issue. So it may look like we haven't considered it again, but if in our view it's the same issue, we would repeat the same response to be consistent. And then just to mention that the bill, as certified by the Office of the Chief State Law Advisor, is the one that was introduced in Parliament. And then on constitutional issues, there was a specific request from the chairperson of SECOF that the committee's legal advisor consider the legal issues. And then on the issue of whether the bill is to refer to NETLAC for further processing, that's of course a decision of Parliament to be made. Then the other concern is that the current version still ignores the need for incentivizing whistleblowing. I did indicate our response to the whistleblowing issue earlier. Then Busa made the point about the triple PFA and would say it was never found on a sturdy and legal sound framework, and it was never going to adequately facilitate the aspirations of 2172 of the Constitution either, which is why we now have to, which is why we now have to have such a similar regulation, which is currently being willfully misinterpreted with some as license to deconstruct Triple BE Act. And this is set in relation to, I think, the current Triple PFA and the 22 regulations that was made after the Constitutional Court judgment. Now, our response on this particular issue is that in clause 2A, one of the objects of the bill is to provide for to ensure an efficient and effective and economic use of public resources. So this is, I think, in relation to the comment of value for comment, value for money by Busa. Now we used this provision as we, I think, indicated in previous presentations because it's aligned to section 195(1) of the Constitution. And then in addition to that, which is an outcome of the NETLAC process, we added in the bill that was also tabled that this must also include the assessment of costs, benefits and risk as well as part of the objective. And then Busa also requested that the bill be referred back to NETLAC to strengthen the basis for getting such legislation eventually signed into law. And the concern that the promulgation of poorly conceived legislation would result in the need to frequently review of subordination akin to trying to convert a donkey into a prize-winning racehorse. Now, obviously, the referral back to NETLAC is again a decision of Parliament. Then Busa's concern is that Chapter 4 loosely mentions a triple BE level and then pre-qualification set aside and subcontracting based on black ownership, which essentially dismisses the balance of elements and targets contained in the BE sector scorecards. That more investigation and consequence management should be applied to companies and rating agencies fraudulently involved in presenting questionable scorecards, rather than dispensing of the holistic perspective in which this act has been crafted to meet section 217 of the Constitution, through which many more people benefit compared to the previously narrow-based ownership alone model. Now, the first point that we would like to make in respect of the BEE Act is that the BEE Act and its sector codes are not only given effect through public procurement, then to delineate, and this is our proposal for amendments to that pertains to triple BE and related matters, is that to make a clear distinction between set-asides in clause 17 and pre-qualification for preferential procurement in clause 18, it's proposed that clause 18(1)(b) be omitted, and that's the one that currently that refers to the triple BE level, and that we instead, sorry, no, that's not the clause. That clause 18(1)(b) refers back to 17(1). 17.3 in the list, and there was a reference error. It should read 17, not 18. That be removed, and that we have clause 18(1)(a) that reads as follow: a bidder having a prescribed minimum percentage of preferential procurement from enterprises that are owned or managed by Black people in terms of the applicable code of good practice on Black economic empowerment issued under section 9 of the Triple BE Act. And so that's a proposed amendment. And then similarly, we'll have to remove the definition of BE status level of contributor that's in clause 1. And then there's consequential amendments if these changes are accepted that should be made to clause 18.2a. So the key proposal on B is the one that's contained in paragraph B on the slide. Now coming to the COSATU and SACTU proposals. Now, the first concern they raised is to address constitutional problems by correcting the absence in the bill of a default or open competition is adjudicating according to a point system, which includes price and preference, and may also include quality or functionality. And then they make the point that it's not strictly necessary to pin down the proportions of the point system in the bill, and it could be done flexibly, done in the regulations. But in their view, it's necessary to embed the principle and framework in the bill. Now, our response is that it's proposed to clearly indicate the layered application of clauses 17, 18, and 19, and that a clause be included or provision in clause 16, which makes it clear that your starting point is set aside, then the next, if it's not applicable, then it's a pre-qualification, and if that's not applicable, then clause 19, which is subcontracting, which also provides for preference. Then also to deal with the issues of another issue raised by COSATU. Sorry, I just want to go back one page. On the issue of price and functionality and so on, we propose now that, which I indicated earlier, that clause 25.1, we add a paragraph that specifically provides that the procurement system with the Minister must set a framework, include a provision that deals with bid evaluation, and that it includes matters such as price, functionality, where applicable. Just in response to that issue. Then on the issue of transparency and anti-corruption measures, I think this is also a matter I've dealt with earlier in this in the submission from the procurement working group. Is that we propose that the definition of confidential information in clause 1 be amended to refer in its entirety to the promotion of access to information. Then on beneficial ownership, this I also dealt with under the earlier submission, that we support the proposal that we reference section 3614 of the Companies Act. In that provision in clause 33. Then COSATU also proposed a national register of excluded persons, their family and known close associates that are contracting with the state, held at the level of and published by the Public Procurement Office. Now, in our view, creating and maintaining such a register is complex and not feasible. And firstly, obviously, the category of persons we're referring to is those that are automatically excluded from entering into contracts with the state, which is in clause 13 of the bill. What we're proposing as a possible clause, it's not specifically highlighted like that in the text, but that we include in clause 33 a clause that if a bid above a prescribed value is awarded to a family member of an automatic close person or a known close associate, that such information be included in the list that the procuring institution must make known when an award is made to a particular or to such a family, to a family member or close known associate of the excluded person. Now, then COSATU and SACTU also proposed that the bill, well, that would be then after it's enacted, be brought back to NECLAC for consideration to assess the strengths and weaknesses of its organization and fix challenges. as well as engaging on outstanding critical matters which have not been addressed during this process due to time. Our response is that Parliament may recommend that the Executive, after a stipulated period following the enactment of the bill, be referred to NETLAC for a review. Then the next stakeholder, Dr. Mokonweni, I hope I pronounced it correctly. Now, you also raised a concern about clause 17.2a. Now, because it currently refers to evaluation according to functionality. So what we propose in our response, that 17.5 be amended to only provide for a bid evaluated according to the prescribed criteria. So that will be determined by regulations, and that the other elements of 17.5, which I did mention earlier, we rather be included in a separate provision, which then will ensure that there's a balance between, among matters like preference, price, and functionality or quality. I think that was dealt with. There's other proposals that we also made, which was during our engagement with Dr. Mokonweni, which is in the report. Then the CSCC. Now, their concern is about the trumping clause in the bill and in 3.4, and their view is it will result in the demise of BBBE in all its dimensions, in particular, but not only the impact on skills development and enterprise development benefits, which have made a great impact via the BBBE Act and its specific, the sector-specific codes, and they propose its removal. Now, firstly, the aim of the trumping clause in 3.4 of the bill is that public procurement is regulated through the bill. And now we're removing merely because of the BBBE Act concern may give rise to conflict with other legislation. Now, the BBBE Act and the sector codes, and as we indicated earlier in our view, is not only given effect through public procurement. And then we made a proposal which I highlighted earlier in amending clause 18 to remove the current provision that refers to the BBBE status level of contributor, that instead we have a provision that reads as follows. I'm just going to repeat it because I think it's quite important for considering the relationship between the procurement bill and the BBBE Act. A bidder having a prescribed minimum percentage of preferential procurement from enterprises that are owned or managed by Black people in terms of the applicable code of practice on BE as issued under Section 9 of the BBBE Act. Then the IRR. Now, firstly, their concern is how generally are BE premiums to be calculated under the bill. And they're stating that Treasury has repeatedly failed to address this issue clearly. And if we don't answer this question, it effectively tells the public that it will ensure that premiums are paid under the bill without any transparency about the amount of expenditure control over that amount. Now, our response that firstly, that in Chapter 4, we seek to address fundamental constitutional provisions in 2172 and 3. And it makes provision for regulation to be drafted with the necessary conditions, thresholds, parameters to ensure that these preference measures are implemented in a responsible manner. And this will also look at provisions to address negotiations with bidders, which is envisaged, which include, among others, the negotiation of fair market price to prevent government paying exorbitant prices for contracts awarded. And I mentioned earlier that the proposed amendment clause 24.1 that we include provision for bid evaluation, and which will include matters like price and functionality where applicable. Now, another issue raised by IRR is, have Black-owned business been paid more than all other private companies? And then they referred to the data on the documents that were submitted to SECOF in earlier this year. And their assessment is that 5.8 billion was paid to black-owned companies, 48% of the sample and 60% plus of the sample, excluding payments made by the state to state-owned enterprises. Now, at this stage, our view is that, or what we submit is that the statistic provided here needs further interrogation and verification against all reports that were submitted to SECOF, which was information obtained from the BEE Commission. Now, the reality is that these statistics may be misleading and that the measurement of BBBE is based on the broad-based nature of the Act itself. For example, it's possible for a company that attains level 1 of BBBE may have no black ownership. So the statistics must be considered in that context. Then IRR also raised the issue of unfunded mandates in relating to provincial budgets, and referring to, I think, statements that was made when we had the engagement in Gauteng about whether there's no new powers or maybe new powers. Now, and also the provisions stating that the powers of set-asides are clearly new and will reside in part in provincial government and designed by Treasury's own submissions to have financial implications, since Treasury says it tabled the bill due to complaints that the current system does not go far enough in its premium provisions, but that these unfunded mandates have not been projected in the memorandum as required by Section 55 of the PFMA. They firstly want to make clear that Treasury did not state that it tabled the bill due to complaints that the current system does not go far enough in its premium provisions. Our statement was about preference measures not going far enough, not about premium provisions. Now, under the current legal framework, provincial institutions under the PFMA and regulation must have its own preferential procurement policies and implement these policies. Now, the financial implications of Chapter 4 of the bill will be important consideration in development of the applicable regulations, and also for institutions when determining their own policies in this regard. So it's not possible at this stage to project the associated financial implications for provinces in the context of Chapter 4. Then IRR proposed a no tie-break provision, which would reiterating that we reject this option of race as a tiebreaker by seemingly to falsely claim that 2172 requires that the procurement framework must trade off cost effectiveness. And the tiebreaker provision was that everyone competes for a particular matter, or it's our understanding. And then if there's the same scoring of, for instance, a black-owned and a white-owned company, then it's awarded to a black-owned company. Now, we do not support this provision because 2172 of the Constitution states that 2171 does not prevent organs of state from implementing a procurement policy that provides for preferences in the allocation of contracts and the protection or advancements of previously disadvantaged by unfair discrimination. Then another stakeholder that we met following a submission that was made to SECOF is the military veterans. Sorry, I don't have the full name. Sorry, the military Veterans Liberation War, the MK Liberation War Veterans Organization. They proposed that military veterans be included in the category of persons in Clause 17, which deals with set-asides, because they are currently provided for in Clause 18. Now, we propose firstly that in response to this proposed amendment is that the definition of military veterans in Clause 1 we replaced by the following definition: military veterans means any South African citizen who rendered military service to any of the non-statutory military organizations which were involved in the SA Liberation War from 1960 to 1994. And then we proposed that military veterans be included in 17.3 as a standalone category. And then also there's a list of categories dealing with small enterprises that are also be included as a subcategory. Sorry. I think that's dealt with here. So it will be small enterprises owned by military veterans, and then there's a provision about prescribing ownership. And then their concern is that if you only have military veterans in clause 18, and you read it with 18.3, which allows institutions to select only particular ones, that they may be left out. Now, in our view, now that there is a proposal to include military veterans in clause 17, it's sufficient since they would qualify for set-asides for which the minister may also set targets for institutions. Chairperson, sorry, thank you very much. That's the end of the presentation. I don't allow if my colleague wants to add something. I just want to say one aspect about the constitutional implications. We dealt with that, I think, more thoroughly in our presentation that was made in March in that report. So it's not, obviously it came up in our engagements now with the stakeholders that we met from 18 to 10 April. But we did deal with that in detail in that report that we made to the committee then. Thank you very much.
Willie, do you want to say anything?
Thank you, Chair. Let me just quickly maybe just add around the issue on unfunded mandates, which I hope that's clarified. What we wanted to say there, Chair, is that currently, in as much as we may have omitted, mentioning of the, projected financial implications, but currently it's not possible for us to quantify the potential financial implications. But we do, of course, understand that there would be financial implications in certain instances, of course, Chair, that relate to the application of this bill. That's the first thing. Then the second thing that I also wanted to emphasize is around the fact, made by one of the stakeholders that the information on the outcome of the tender processes must be made available within 14 days. I think that's, they were saying 14 days. And hence we're saying, at least with the introduction of the tribunal, there are certain steps that, any bidder who may be aggrieved by the outcome of the tender process must follow. And firstly, you may go back to that procuring institution to raise your issue. And that takes time by its very nature. And also you still need to run through the tribunal itself if you are still not happy. And so the 14 days that's proposed there is actually inadequate. Then the one other issue, Chair, that I think is quite clear, and I think the advocate here, clarified the issue around Parliament and legislatures, and I'm sure also Advocate Jenkins will come in that particular area. The one other issue, Chair, is the one that was raised by BBC, which was saying at least is something that probably may need to be discussed further around what they're proposing in terms of what they submitted through. So these are some of the issues, and the issues around the locus of where does the power lie in terms of the determination of a procurement policy. And I think we've made a point there, although some stakeholders still not entirely happy, especially looking at the JSR. But at least that issue as well, I think the advocate also clarified that at least we're making certain amendments in certain clauses of the bill to make sure that at least there is the development and the implementation, that it resides somewhere within the procuring institutions. So I think, Chair, in a nutshell, this is what I wanted to add. And as to the last part, of course, that is made by COSATU and SACTU around the register of a prohibited person, let me put that way, who are not supposed to submit bids. We're saying it's a very complex issue because if you look at the entire state, when you're talking all state institutions, all officials of government are not supposed to do business with the state. So that's a first thing. So the question would be, how then do you put that register? Is it a register that would be maintained by the PPO? And what happens with when people leave the employee of the state? And then what then, are the roles of other departments such as the DPSA to deal with the issue of that register? So we said at least it's something that we need to look at it and then carefully before we can provide for it in the bill, and also look at its implication, whether legal and so forth. So these are just some of the issues, Chair, that I thought maybe we should. I'm just going to add on what the advocate has indicated earlier on. Thank you very much, Chair.
Yeah, thank you very much, Treasury. I think you've done a very, very comprehensive job. I know it took a lot of work, many hours sitting with the stakeholders and now reporting to us. So it's very extensive and very comprehensive. Obviously, members, we aren't able to internalize everything. And we've got plenty of time between now and next week, Tuesday, when we meet again, to read and understand more the issues raised. Colleagues, comrades, I know that it's quite tough, having to listen to all of that, but the procedure, as you'll know, that we best deal with, because they may hear both sides, is to hear the stakeholders. We're drawing this process of consultation with them to a close. If we need any further inputs from them, we'll go back to them, but for now. So I would suggest, I think in Kuleko, there are 11 here, aren't they? Well, I really don't see the need for everybody to have 5 minutes. So you can take a maximum of 5 minutes. That'll take us to, almost 12. And then we need to decide on how we go forward. So I'm afraid we'll have to hear more, and then we can start the discussion, but it's only the first foray into it now, since this consultation process. So ideally, those of you who are now going to speak, I'll take it in the order you appeared, Institute of Chartered Accountants onwards. You'll not exceed 5 minutes. You don't have to use 5 minutes, and focus more on what it is that Treasury said that's not accurate about how you feel or what you said, and say something new. Don't go through what you've already said to us in the public hearings and what you've said to them that they've covered, really. Because now it's for us to make decisions, not to hear you say the same thing again. You also, most of you, made similar representations, from what I can gather, but I shall check to the National Assembly Committee, and clearly they applied their mind, and clearly they turned you down. So it's not like you're coming to the first time to Parliament. This bill is in its second phase in another house. But over to you. Chartered accountants, please, I shall monitor you according to the stopwatch. You might want to do that to yourself as well. Okay, let's go for it. Where's chartered accountants in Kulileko? Are they here? Excuse me.
I don't see them here now, Chairperson.
Okay, let's go to Public Affairs Research Institution. They're not here either. Okay, Business Unity South Africa? Not here either. African Procurement Law Unit, apologize. Joint Strategic Resources.
Apologies, Chair. I've a bit slow on the to unmute.
Who's this?
From Busa, Chris.
Oh yeah, please, yeah, go ahead. You got 5 minutes maximum, please. Don't use it all unless you have to.
I don't plan to. Thank you, Chair.
Good.
I think that you know, the absence of the deliberate distinction that needs to be made on strategic and general procurement still bothers us in that the only reference to that exists in probably 2 lines in this bill, yet we seek to make quite a big difference. We are not convinced that the Treasury quite have, or the team there have quite appreciated why it's necessary to expand a little bit more on that in this primary legislation. I think the presentation from our medical practitioners on equipment sort of alludes to that because that would be strategic. So we're not convinced that there's been an absolute applying of the minds here. And then finally, Chair, much as we hear that there's been cross-consultation, I certainly hope that, you know, after all of the work and the effort that everybody's put into this, including your committee and so on, that there has indeed been confirmation of the constitutionality of your Chapter 4 in this bill, for example, so that once we get going and you start collapsing procurement as it exists in MFMA and PFMA and start driving it through this, that we don't run aground with legal challenges then. So I certainly support your perspective at the beginning of the meeting, where we are not all constitutional law experts, and I trust that advice has been taken. Thank you, Chair.
Thank you. Can we have, what's this? JSR, Joint Strategic Resources. You're here. Go ahead, please. Okay, next, NRF. Are they here?
Yes, we are, Chair.
Go ahead, NRF.
Thank you, Chair. Less than 5 minutes. Firstly, on funding. National Treasury claim they cannot empirically quantify. That's not unacceptable. They can project in terms of the appetite. National Treasury, which is the financial management exemplar, should be saying, what is our appetite for a 2172? Is it $1 billion? Is it $1 trillion? What is our appetite? And then you work backwards from that. So they are prejudicing this particular act, because if it's challenged because they haven't got the costing or a projection, and this kicking the can down the road just doesn't work, they should be able to put down an appetite figure, a budget figure, and then work backwards from that with subsequent things. Secondly, Chair, is the standstill period. That's going to retard service delivery. It's critical. And I just want to mention Prof. here also made that point, and they are silent on that. The Constitution also speaks about efficiency, also speaks about service delivery. Thirdly, is when they summarize the NRS view in the slide presentation, they said nothing about the effectiveness of National Treasury. That was a key point, even in our detailed 300 pages. It was a key point in our 3-pager. But if we're going to go with National Treasury and the PPO being part of National Treasury, we need to have checks and balances. We need to have accountability. We have to consider best practices internationally. And they're there. There doesn't seem to be an appetite. They seem to be self-serving. They want to tell everybody else what to do, but there's no accountability in terms of what they should be doing. Number 4 is donor funding. internationally, if your donor funding is over 50%, it makes sense to be subject to regulations. If it's less than, no. Why can't we write a smart act in which we specify what those exemptions are? And this is, in our view, a clear international best practice. Why do they create this bureaucracy where everybody must apply for exemptions when the rule itself is ridiculous? Then the next point is, and I'm referring here to Sherlock Holmes, and he kept asking, what is missing? Why the dog didn't bark? So what is missing? There's a lot that's missing. So we are commenting on what is there, but in our 300-page line item, and we've only had 10% from National Treasury on that. They still haven't responded to the other 90%. But what is missing? Basic definitions on what are the key definitions for fairness, equity, cost of competitiveness, and transparency, and a whole lot of other definitions. Then, Chair, to end off, and hopefully I've been less than 5 minutes, is the NRF would like to repeat the offer that they can second from the NRF somebody for up to 3 weeks, should you require any assistance in any process and any clause by clause. I'm not sure how good that is in terms of the legality, etc., but just take us as being available to assist, should you require. And just to summarize, and I know I might be preempting the next item on the agenda, but we don't believe that this bill is ready for promulgation. Thank you, Chair.
Thank you. Then we go on to who's next. Let's see. It's Kosato and Saktu. Then public service account. Yeah.
Thanks, Chair. Much appreciated. Greetings to you, greetings to the committee members. Chair, I'll be really quick. I apologize for the noise in the back here. There's construction behind me. Chair, we appreciate the time that the NCOP has given to do additional work on this. We appreciate the availability of National Treasury. There are some improvements in the bill before us. We have to admit it, there has been movement. So we really do appreciate that. At the same time, Chair, we have 3 concerns. Firstly, it's hard to determine the effect of some of the changes because we haven't seen them, the textual form of them yet. So it's hard to figure out what really has worked, what hasn't. The second, there are some larger unaddressed structural issues. Other colleagues, other stakeholders have raised some of those. Third issue, leave aside all of this stuff, we still need to see how this bill is going to work when it turns into real life and it hits the ground. So a couple of issues. What's been won? What are the risks? There are some structural issues which have remained unaddressed, and how will this all play out? Which brings me really to the kind of final close, Chair, which is on 2 things. The first, and Treasury has really opened the door really nicely on this, both in our bilateral and in these meetings. They keep saying it's up to the NCOP to make a recommendation that this bill goes back to NEDLAC within 18 months for further consultation. So Chair, we want to appeal to the NCOP. This would be an absolute critical belts and braces approach to the current bill, that within the next 18 months, it comes back to NEDLAC and we work through some of these deeper issues. We want to appeal that we get that request, please, from the NCOP. The second part of that then, Chair, is that the same should be there for the regs. Now, I understand from Comrade Matthew that has been done. We do sometimes bring regs to NEDLAC. On both of these issues, obviously it's not in the interest of Treasury to come back to NEDLAC to negotiate with us because, they don't really want to bind themselves and all of that. And we understand these are busy colleagues, but this is an extraordinarily important bill, extraordinarily important regulations. So we seek the intervention of the NCOP for a belts and braces fix. I don't know if my comrade Matthew just wants to say anything just in closing, but thank you, Chair.
No, Chair, I can come in very quickly for 20 seconds. Look, I think just as Simon said, we appreciate the engagement colleagues for Treasury have had with us at NEDLAC and Parliament in the space NCP gave us. Look, we do recognize that in all reality, Parliament would most likely pass the bill now, it would be difficult not to. But I think that's why the kind of plea that, in the committee report, recommendation, as Simon is saying, let's have a supplementary bill in 18 months and see what we need to strengthen further, one. And we'd also have got some practical experiences too. And I think Treasury also did speak to a model policy for the CPO, and I think they spoke to a constitutional clarification workshop too. That might also help. And I think it should also be helpful in the committee report too, that we also recommend that when the regulations do come, because regulations will need to come, and we would hope during the course of this year, given the importance of this bill, that also does come to NEDLAC, and then we can see how we can expedite matters. We don't need to drag them out, but we do need to just make sure we have the final product as strong as possible, given how important it is, Chair. But yeah, let me stop there, and thanks, Chair members.
Thanks. Public service accountability is next, and then SAMED, and willpower follows. Are they here, public service?
Yes. Yes, we're here.
Please
Thanks
go
very
ahead.
much. Thanks, Chair. We don't have much to say. I think we appreciate the process. It has been helpful to understand the National Treasury position. For example, the response on the we proposed putting a set limit on the amount of time for publication of procurement information. So yeah, we understand. I think we're still concerned about this idea of the extent possible. What we've seen is, municipalities who don't have a printer say that they can't scan documents, and this remains the sort of situation for months and years. But yeah, we see the response there from Treasury. I think for us, we just hope to see a really radical improvement in the commitment to transparency and the implementation of the bill. We've highlighted our concerns with the existing platform, and so we do hope that this change from the instruction notes to the regulations will really make a dramatic improvement. We also hope to see better enforcement of the regulations to ensure that the portal, the ICT system that is put in place, is complete and that the information is accurate, and that it really becomes possible for the public to monitor procurement in a much more meaningful way. Thanks very much. I'll leave it there.
Thank you. Who's next? You know who you are. SAMED, are they here?
We are indeed.
Please go ahead. Thank you.
Thank you. So we would just like to also thank National Treasury for the time that they provided us. It was slightly cut short, but we appreciate that. I think the one key area that we still feel was not addressed was our recommendation to include under the Bid Specification Committee section that it should be mandatory to have a specialist on those committees. At the time, National Treasury said they would consider this, but we didn't see it in the presentation today. Thank you.
Oh, you're done. Fine. Then who's next?
Willpower.
Willpower. Yeah, go ahead.
Thanks. Thank you, Chair. Thanks for all the opportunities. Just to maybe expand a little bit on the point that we've raised around the application of the bill to parliaments and provincial legislatures. I mean, just practically from what we see is there's a fairly small community of procurement people that work in parliaments and provincial legislatures. And they rely incredibly on the support and the training that exists for the rest of the public procurement community. And by excluding provincial legislatures and parliaments from the core of the bill and just making the Chapter 4, the preferential procurement, applicable, is going to create a difficulty within the capacity, the people, the training, the systems that will be used by Parliament and provincial legislatures for this. So looking forward to hearing what Advocate Jenkins says about the constitutionality of that. Chair, we welcome the other changes that have been proposed by Treasury. I think the one that they have mentioned where they propose that the procurement function be moved away from a reference to department to more explaining that there are responsibilities across the institutions. We're going to need to unpack that fairly carefully, because that is a very significant and very clever proposal that they've made. Last point, Chair, is the issue on the standstill period. We don't believe that the clause as it stands now addresses the practical implications that we're going to have in institutions. And perhaps, Chair, Vili, we must maybe look at moving this entire standstill clause to the regulations. I'm not sure it needs to be in primary law. I think it's something that we can debate more in detail at a regulation level. And that might just give us a better opportunity to make sure that it is practical. Thanks, Chair.
Finally, it's IRR.
Thank you very much, Chair. Hopefully, last but not least. Yeah, I want to reiterate that we really appreciate the time, the engagement, and I specifically want to just draw attention to a proposal that Treasury made in response to our submissions, our legal submissions, that the may changes to must in clause 62 in terms of deviations granted from instructions. I think that's important for the committee to look at, and it is a bit of common ground. It didn't come up in the presentation, but it is in the slides. As the chair said, there'll be time to look at those more carefully later. So yeah, that's great. I'm not going to repeat stuff. I'm going to say fresh stuff here. So in terms of the black-owned data, the chair of this committee asked Treasury for data on, what's happening with procurement and BEE today, and Treasury provided some of that, and from this central supplier database, and covered over 1.2 trillion rand. And I really implore the committee to look at that. Slides 20 through 26, I think it is, of that Annexure A deals with, it says level status, BEE, I think level status 1, 2, 3, 4, 8, 5, 6, 7, 8. And then it has, each year, how many companies received what by BEE levels. Before that, slides 4 and 5 say black owned. And slide 5 defines black owned companies as 51% black owned or more. And that slide says that black-owned companies received 588 billion rand out of the 1.2 trillion rand, roughly, that's covered in the survey. So that's about half. And then there's a lot of that 1.2 trillion is paid from the government to SOEs. Government departments also have to pay for electricity. So that's not really in the private sector. So if you exclude that, it comes to black-owned companies are getting 63% in the survey database of the relevant of procurement expenditure. 63%. That's a majority. It's not demographically representative. No one's saying that, but it is a majority. This is important. In our meeting with Treasury, everyone conceded that it matters what are the facts on the ground. This thing is about leveling the playing field, so it matters how level is the playing field already. Now, my concern here is that in the presentation just made by Treasury, in response to this, they're still saying that those aren't black-owned companies. The advocate, Van Schoor, was saying that the data is misleading. It's written there, this must be further interrogated. Maybe it's misleading. The data is coming from Treasury. There is a responsibility on Treasury not to give misleading data. And if the data is misleading, to explain why it's misleading. At every stage, we've asked Treasury, We sent a letter on March 18th. We made oral submissions. We sent a letter again. We want to know if black owned 51% plus does not mean that, although Treasury wrote it, what does it mean? And Treasury keeps saying, you know, there's a difference between black owned and BEE level 1. And it's like, yes, BEE level 1 numbers are different numbers. They're at the bottom of the slideshow. We're not talking about that. That comes to a different number. We're talking about the 588 billion at the top. Furthermore, Treasury earlier submitted in a separate context that the CDS data is representative of procurement more broadly. And if that's the case, then you're looking at trillions of rands that have gone to majority black-owned companies. Does that mean transformation's over? Does that mean apartheid's, you know, legacy is over? No, but it is relevant to this committee. And I don't know how it can be that at this stage of the process, you know, there's still no clarity on what it means one way or another, how this vindicates real public participation on the basis of transparent information sharing. That's a major concern for us. The other concerns are a bit more briefly, you know, and it's a new one because it's fresh. Right now, they're still saying that we've got it wrong. Black owned doesn't mean black owned. And it's the second point is on the premiums. You know, if you look at the first slide that of Treasury's response to IRR legal, we ask a simple question: how are the premiums going to be calculated? And Treasury's answer is, in effect, that there's going to be no premiums. They say, you know, look, there could be premiums. The Constitution allows for it through 217, 2 and 3. But then the last sentence is that there will be negotiations of a fair market price. So then there won't be premiums. This is the, you know, we're playing hide and seek with premiums here. Treasury made it very clear to the committee that there will be premiums, that this is what the bill, part of what the bill is providing for. That's understandable. Treasury's made it very clear. It believes that the Constitution allows that. Sure, that's Treasury's position. The question is how much? And when we ask how much, Treasury says, well, effectively nothing because it's going to be fair market price. That's not good enough. Then on unfunded mandates, Treasury said now, to read its response, which the advocate just read out again, Treasury did not state that it tabled the bill to complaints that the current system does not go far enough in its premium provisions. Our statement was about preference measures not going far enough. But there's no conceptual difference. The preference measures are what create the premiums. In the current system, there's an 11.1% premium cap, as Mr. Matabula said, for large contracts, and then a 25% premium cap on smaller contracts. And the set-aside and pre-disqualification scheme that this bill will make into law, if it succeeds in passing, will remove those premium caps, and there'll be a new way that premiums are sustained in the procurement system. The premium and the preference, I mean, they're called preference premiums. That's often how they're described. Mr. Matabula said, you know, you can call them preference premiums, you can call them BEE premiums. It's the preference in Public Procurement Preference Framework Act. That's what provides the premiums. In the new bill, it's done through pre-qualification and set-asides, but that's still how the premiums get in. And so, you know, the question is, how much is that going to cost the provinces? I just don't think it's well addressed. I know the Treasury is going to speak after this, so like, as a direct question, I would appreciate if Treasury could answer this specific question. Treasury's representatives have said repeatedly that national legislation in the Constitution, in particular in Section 216 of the Constitution, refers both to primary legislation, in other words, what this committee is involved with now, as well as subordinate legislation, in other words, when ministers pass regulations. I'd like to know, in terms of unfunded mandates, in Section 35 of the PFMA, where it says national legislation, when it's drafted and tabled, must have a memorandum that says how much is this going to cost the provinces if they're getting new powers or responsibilities. Does that national legislation phrase in Section 35 of the PFMA also refer to both primary and subordinate legislation? Simple question. That clarity would be very welcome. And then I'm going to finish with this, the tie-break point.
Yeah, please do.
Thank you very much, Chair, for your indulgence. This committee is involved with passing legislation. Every time that happens, and there's any potential infringement on rights, Section 36 of the Constitution is the lawmaker's guiding light. And Section 36 of the Constitution says, inter alia, that you can't do anything to limit any rights if there was a less intrusive way to achieve the same purpose. So this committee's purpose is transformation as it understands it. Sure. If there's a less intrusive way to still achieve 2, 17, 2, and 3 interests, and the committee doesn't choose that way, then it's failing to pass the constitutional test of 36. That's why we brought up the tiebreaker. And Treasury said the tiebreaker is consistent with the Constitution. It's a way to do transformation. It's just not a good enough way now because the playing field is not level enough. If it were level enough in 20 years or 30 years, you know, as things have changed, then maybe just a tiebreaker would be the way to do it. That's what Treasury said. So the question is, how level is the playing field? And that brings us back to our first point. No one here knows how level is the playing field because Treasury said in its document, Annexure A, that black-owned companies are getting more than white-owned companies, more than all other companies from procurement.
Please round up.
And then it said,
I mean, you've gone.
And then it said that's not
5
true.
minutes. You've gone substantially beyond 5 minutes. Now I'm ruling. Can you round up, please?
Sorry, Chair, that was my last sentence, so I'll just repeat it so that it gets out. Thank you very much.
Good.
Treasury says, no one knows here how level the playing fields are, and therefore no one can figure out what kind of limitation on rights needs to be done through set-asides and pre-qualification. Because Treasury has said on the one hand that black-owned companies are getting most of the procurement payout, and on the other hand said that that's not true and that their own submissions are misleading. That puts everyone in a confused position where they can't make an informed choice. It's highly unfortunate. Treasury should come back with a very clear picture of how level the playing field is so that the committee can use that to inform its decision, especially in light of Section 36.
Okay, thank you. Right, there's somebody called Caroline who wants to speak and she's getting slightly, if I'm right, hysterical there. I don't know. Nobody's excluded anybody. I got the list here. We asked for all 11 who were supposedly here. Several weren't here. Somebody is here who is a stakeholder. Can you speak now? Who would you be exactly representing?
Sure. Thank you, Chair. My name is Caroline.
Who do you represent?
I'm representing the Procurement Reform Working Group, the PRWG. That was one of the stakeholders that National Treasury
you weren't
responded.
mentioned. I think our excellent secretary forgot to mention you, for which we apologize. But nobody's going to be excluded, right? There's no deliberate plot to exclude you.
No.
Because I don't like your nose or something. It just doesn't appear here. It's a human error from Nkuleko's side. Go ahead. You've got up to 5 minutes, not more, please.
No problem. Thank you very much for giving me this opportunity. Firstly, I'd like to acknowledge the report and the engagement that National Treasury has done in response to our submissions, but would like to note firstly that we have had very little time to engage with the report in preparation for this meeting, and more substantially to note that although we've had this engagement with National Treasury, we are slightly concerned that the engagement has been limited to Treasury rather than with the committee itself. And so we have been unable to engage with the views that parliamentarians might have on the various issues in the bill. And so would like to note that ideally there would be a further opportunity once you, as chair of the committee, and your committee members have been able to fully engage with National Treasury's responses, for us then to be able to understand what Parliament's views on the bill and these proposed changes are. And then I would also just like to note that although we recognize that there have been some small changes that have been made to the bill in response to comments raised by both us as the Procurement Reform Working Group and other stakeholders. Firstly, to echo Kasatu's comment that we still haven't been able to look at the textual changes to the bill, and so we aren't able to fully examine how those changes have been implemented. But more substantively is that the engagement that we've had with National Treasury has been very narrowly constrained to making comments on areas that can be easily fixed by a correction of, for example, a reference to the incorrect provision in the Companies Act, rather than being afforded the opportunity to engage with the really nitty-gritty, big picture constitutional issues that we believe still remain with the bill, and that our submissions to National Treasury, as I said, were constrained in that way, and that there remain really complex, difficult issues in the bill that require rigorous consultation and rewriting, that the timeframes that have been given in this process just don't allow for that engagement, which we think, and we reiterate, is a sort of concern with the bill. I think I'll close there, and I know there are some other colleagues from the Procurement Reform Working Group on this call. If anyone, I'd give them an opportunity to add something in, but I think that's the gist of our concerns. Thank you very much, Chair.
Well, a team, you're entitled to 5 minutes, but I can't decide for you. There's nobody in your group that wants to speak that I know of, so can we move on? If somebody in the chat group wants to speak, who would they be? We need to move on. Sir, can I give you some input response to who would this be? Advocate Nandipa, are you from which structure?
Good morning, sir. I'm Advocate Nsaluba.
Yeah.
Yes.
Which structure are you from?
From the military veteran space.
Oh, yeah. Okay, fine. We've agreed to your proposal, so I don't know what you want to say, but go ahead.
Thank you, sir. I just wanted to appreciate that. But as I'm looking at the input, if it's an extract, you'll forgive me. But there's an interesting inclusion in the definition of military veterans, clause 1. And the way I look at it, it seems to be extracting just the A part of the definition of the military veteran from section 1 of the Act. And I'm wondering if that would then not cause a challenge, because the definition is threefold. That's one. The second one, say, if you allow me, is a plea, which I provided in writing, again, with regards to military veterans' experience of writing regulations, that we had pleaded that section 58 of clause 58, should not only confine itself to 2 ministries. The experience that was gathered during the military veterans regulations development process signified that you need to look at the organs of state that are affected by that particular benefit. And we're pleading that the same approach be adopted in developing delegated legislation in this space, because by their very nature, they are going to triangulate across various constitutional institutions. And we're using the military veterans benefit regulations as an example. And lastly, probably, sir, if you allow, is the reference that we had made to consultations with the information regulator, especially with issues that deal with data privacy, data, because that's the institution that is seized with that responsibility, that it be peremptory, that the consultation be done by the unit on any matter that deals with data, so that we are not superfluous in dealing with that. Thank you very much, sir, for allowing us, and thank you for the great work done by the National Treasury in this regard. We're looking forward to further engagement on other issues. Thank you, and thank you all.
Thank you. I hope you raise these issues between the 8th and the 10th, right? And in your letter to us, which was referred to the committee, these other issues weren't raised, but no doubt Treasury will reply. Now over to members, and then we'll come back to Treasury, and then we'll decide on procedure from here with, henceforth. Dennis? Yep.
Yeah, morning, Chairperson. No, it's just gone afternoon. Good afternoon, Chair. And thank you for the opportunity. Before you accuse me of being too white again, let me just try and adjust my filters on the video. There we go. Good.
You look
thank you very much.
in the earlier mode.
Chair, yeah, I think that you preempted some of my comments at the beginning because, yeah, let me start by first of all appreciating the manner in which this has been handled, because I think that Treasury's level of consultation and the interactions with the stakeholders that have raised their concerns is most welcome, and it really shows a maturity of legislative process. So I mean, it was this committee that suggested it, and I think the way it has been carried out and take forward, I think is very constructive. And let's face it, this is a contentious piece of legislation that requires such a level of engagement. Having said that, Chair, I mean, look, having the documents sent to us last night at 5 p.m., as you pointed out, Chair, this is complex stuff. It's certainly a higher grade, and I know that you've said that we've got a week now to digest what's been sent to us. I do think the slides were quite brief, and a lot of the presentation that was given today presupposed a level of understanding of what went on in the discussion. So I think that the slides in the presentation were certainly a lot more meaningful to Treasury and to perhaps the stakeholders that participated than it was to members. And I mean, I sat last evening trying to work through and cross-reference between the slides and the supporting document and the Act, and it just became, quite messy and hard to follow in certain instances. And realistically, I mean, getting it last night was not helpful to really going into depth into this. Now, I mean, I realize this committee has in the past worked with considerable agility, and we've accommodated late submissions and last minute things. But I'm aware many other committees required presentations to be submitted a week before the time and so on. So I just wanted to put that on record, Chair. Although, as you said, we've got some more time to get our heads around it. And I think I'm going to need that, because this is serious high grade stuff. There's a lot of things that need to be understood. I do want to just, take a moment to consider the responses overall. And I'm not going to get into individual issues, but I mean, it seems like it's common cause that there are going to be another round of fairly substantial changes to the bill before it goes through. And of course, that's going to precipitate a referral back to the National Assembly. So there is going to be a backwards and forwards process again. And looking at our timelines and the programs of ourselves and the National Assembly, Chair, I look forward to hearing what your proposals are in terms of taking this bill forward, because I do think that the call has been made by a number of people that this needs to be, taken back to NEDLAC. I'm not sure that NEDLAC's the be all and end all in terms of the further consultation process, but that's the call that's been made. I think that it's been repeated by many of the stakeholders, and I think that Treasury made a comment in their presentation that that's for Parliament to decide, which is us. And invariably when Treasury makes something like that, it means we probably agree, but it's verging into the political space, and we don't want to shout too much about it. But Chair, based on these substantial changes to Chapter 4 that were made in committee in the National Assembly, and I think Mr. Epple made the point earlier on that when we're making kind of broad decision changes here and proposing changes, you don't actually get to see the final text. So the National Assembly proposed changes in their committee, which then resulted in the A bill and the B bill coming through, and yes, we've got our heads around that process now. But they ended up voting on a bill that they hadn't seen the final text of, and that's where, you know, the differentiation between single words like may and must becomes important, and that's why we do clause by clause. So I do think that there's substantial value in considering a reference of this thing back to NEDLAC. And I think, you know, just noting the volume of changes that have been made already and the further changes that are now proposed, we're going to end up with a very, very different looking bill at the end of the day from what entered the National Assembly and went through the first rounds. And I believe that there is still a lot of space to go in terms of getting an appropriate bill. And I mean, it's important if one considers the budget of national, provincial, and local governments all combined in terms of their procurement processes. You know, if we don't get this right, we are going to stymie spending for quite some time. And I do think that the constitutional issues that have been raised are material enough that it does need further discussion, certainly to bring people onto the same page. Because, you know, if you read between the lines of some of the inputs that we've had today, you know, you can already see the litigation loading, which is going to delay and throw huge stumbling blocks into the procurement processes once this bill, if it does get passed, gets passed and enacted and put into place. So, Chair, yeah, I want to really thank, again, just in closing, all of the stakeholders, because they've certainly enriched the discussion and helped us to hopefully get to a point where we will have a better product at the end of it. I want to thank Treasury and yourself, Chair. Well done. Thank you. I think I've given you a heart attack by saying, oh, there we go.
No, I'm looking for who wants to speak. I see there's nobody else here. All right, in that case, I'll come in. So firstly, yes, I agree with you, Dennis. I actually got the report on Monday afternoon, the text one. We got the slide presentation yesterday. It was a lot of work. And Willie approached me on Friday, was it on Thursday? I can't recall, to say, look, we can't deliver it by Friday, 12 o'clock, which is what I wanted, noon. And I said, I understand. They had 3 days of sittings. So, and I think it would, your concerns will sort of have more substance if we didn't have a lot of time left. So now that the National Assembly is meeting, I think for a 2-day sitting, I think it's 2 days in Kululeka, I'm not sure, this month, and towards the 3rd week or so, or is it the middle of May, we've got plenty of time. This is the only bill we have. Moreover, we have few plenaries in the week ahead. So we can sit 25 hours a day, 8 days a week if you want, metaphorically speaking. Oh, by the way, Caroline, when I referred to your nose, I wasn't literally referring to your nose. What I meant to say, you weren't excluded because, okay, of the glasses you've got, because I hadn't seen your glasses or your nose. So obviously it's a metaphorical statement, not a physical one. So, you know, I'm just saying we metaphorically, we can sit all the time. So I don't see a big issue. This is just like an initial foray. We're just looking at what came out of the 8 to the 10 process. So yes, it was hard to follow. I also had the same issue. But we've got plenty of time. And the thing that strikes me, National Treasury and the stakeholders, is it's like a completely, we've never come across this in the NCOP in this 5-year term. I don't know that many other committees have come across this, very rarely, where, you know, so many changes are required in a bill. So what exactly happened on the NA side? I don't know, but they applied their mind. I do not know, Frank, you must help us here. We're being told that the NA voted on a bill that they never saw. How is that possible? So Frank, can you explain how it is possible that a National Assembly committee and the House can vote on a bill they didn't see. On the final text issue, yes, I think the stakeholders are right. They need to see the text because ultimately that's what counts, not the policy responses from Treasury off the cuff and in words. And we would want to see the text too and match that with what they said they're going to do and what we think they should do between now and the time we start looking at the bill clause by clause. I don't see the need to take any final decision right now. We're just starting. We don't know where we're going to go with this bill, that we're not going to have this bill or we're going to have this bill. I also want to alert members, don't think it's going to be easy if we suspend this process and you're going to get a new set of MPs, probably very much younger. Very few will come from this committee. And even people who come back from this committee often get allocated or deployed to other committees. Like our whip, she could become a chair of a committee because she's now no more serving the first term, right? And she could be deployed to international Turco and so on. So I think the work that has already been done by the NA committee, that too might change. The last experience was only Noxie got back in that committee. And on our side, the only two people who were in the finance committee before, that's Dick and myself. And we were on the other side, NA side. So I don't buy this thing that, you know what, let's pack it off and let the next term of Parliament decide. There's no reason for it at this stage. If we do decide not to go into the bill, there must be a more substantial set of reasons for it. I think there's general agreement, or there hopefully will be in the committee, that we see this as a transitional bill or a temporary bill if we go ahead with it. And that within 18 months or so, the bill be reviewed with the suggestion that it be taken to the NEDLAC process. So that's a compromise we can strike between sending the bill back and passing it blindly, which you're not going to do anyway. I'm not sure that the interpretation you make, Dennis, that, National Treasury is saying, yeah, we agree with you, send it back to NEDLAC. But they pass the buck to us and say, Parliament must decide, because that's what they think. It could also be a diplomatic way of saying, well, we don't agree, but let Parliament make the decision. It doesn't matter what Treasury thinks. It's our call as a committee, we Parliament. So at this stage, I can't see the need to call off this bill. And we must do our job. We're what? 21st of May is the last sitting, I think, of the Parliament. We've got plenty of time in between the election campaign. It's not as if we sit the whole day in the election campaign. And mind you, we can meet in the evenings and we can check when people are available and take into account political party responsibilities. Now, there are some issues that I don't think we need endless discussions about. On the matter of process, no matter how long we sit here, we will still have disagreements. No matter how many workshops you have with the stakeholders, you're still going to have disagreements. Some of the stakeholders' needs and interests contradict with others of our stakeholders here. Furthermore, we can have constitutional workshops after constitutional workshops. These issues are not going to be agreed to. As I said at the outset, the Constitutional Court is the final decision maker on the constitutional issues. Unless the majority think otherwise, I don't think we need to kill ourselves over that. We've covered the ground. The state law advisors have approved of the bill. Frank and them in the legal services seem to have approved the bill as legally and constitutionally sound, and so has Treasury's lawyers. So I think that the real test, if people want to, is to take it to court. There will be legal challenges. Not all of these are dictated by constitutional and legal preoccupations. There are class and other interests involved. Let's get real, Dennis. There are class and other interests involved. There are people who mean well and present their arguments along legal stroke constitutional grounds and technical grounds, but they're not unbiased any more than we're unbiased. So, I mean, we've been through this before. Let it go to the courts if that's what people want. Where there are not constitutional issues but other legal challenges, then again, the courts must decide. We must decide on the basis of the policy issues, the usefulness of the law, and so on. Now, we have got a legal expert here, and I would like him to come in. So the first proposal I've got is that if Frank Jenkins, under the pressures of almost, what do you call it, the penultimate stages of the closure of a 5-year term of Parliament, has got the time and wants to meet with the stakeholders and discuss the legal and constitutional issues, Frank, I think we can give you a mandate to do that, but you're not obliged to do it. What we are obliging you to do, and we can talk offline, is to come here on Tuesday morning and deal with all the constitutional issues. Doesn't matter what Treasury says, they're the executive. We are Parliament, right? You must take, obviously, as you do, the positions of the legal services unit of Parliament. So you can say, here we agree with the stakeholders, here we agree with the National Treasury, and these are the issues that need to be addressed. And so we would like, Frank, you'll come back, whether it's feasible to ask you to do that amount of work, given what else you have to do by next Tuesday, 10 o'clock. Then on the issue of unfunded mandates, I don't think we need a long discussion. Treasury, I've been around for thousands of years, and I can tell you just 90% of the time, when a government department says there are limited financial implications or there are no financial implications, that never works out like that. I find it hard to believe the credibility of what you say on financial implications. But now on the matter of unfunded mandates, basically, one of the issues we can do, although we don't do that because the memo of a bill is not subject to legal scrutiny in the sense of you can effect changes and it has any power of the sort you have in a bill with a particular provision. But still, we can change the memo if we have to make it clear that you had it wrong. On the financial costs as a whole, I think, yes, you must have some ballpark figure that's reasonable in my view. These are my tentative views. Now, I'm entering the area of tentativity. I don't know. My initial response is just to give some idea. We've got we can't waste this, 40 minutes left, but we can't just use it for the sake of using it. But there are some things that occurred to me in a cursory response, on a tentative response. It is that on the one hand, I don't think it's fair to expect you to have a finite, definite figure of the cost implications. But overall, for the spheres of government, it's impossible. It's not fair. On the matter of the public procurement office in National Treasury, for now, I don't think it's an issue. I think people are wanting too many changes in this bill, some that don't fall within your portfolio. It's not an omnibus bill. It affects a whole lot of other departments, true, but you don't need to take on the responsibility of other departments, and you have no right to do so on the eve of an election. So no changes can be effected in this process that have implications for other departments that you haven't consulted. So let's be clear about that. I think our report on this committee will have to, if we go into this bill, will have to be quite long, and it will set out all these things. Remember, a report is not legally binding in the sense of a clause in a bill, right? And later to become an act. So we can recommend a whole lot of things, but we should do so. And we should debate it in Parliament if we get there, and so on. On the things that I don't understand, Treasurer, some of the mistakes that have been made on the NA side and yourselves as the department could have been easily avoided. They're simple ones. We just make the changes, right? Wrong cross-referencing on beneficial ownership and so on. So unnecessary, right? On the register of prohibited persons, I see what you're saying. We need some such thing. But to expect you to have it in the sense that some of the stakeholders are doing, I think are unreasonable, really. The expectations are unreasonable. But you should also, you've given quite a lot in. Treasury, you've given in more than I imagined you would before we asked you to meet with them. So I'm really surprised how far you've gone. And I think we welcome it. But the final test is the text, what you actually say. And you should start working on these things, then we go on to I think I'll stop there for now because my views are very, very tentative, really. And I think that my overall view is, for what it's worth for now, I will read all the stuff properly and so on, is that actually you've been far more conciliatory, Treasury, than the stakeholders have been. The National Research Foundation wants to offer their services. You also understand it's a semi-state entity. It's not a private sector entity. It also has its biases, with due respect to the individual. Everybody has their biases. But, I don't think Parliament can prescribe to National Treasury who they should draw on. Frank, you should maybe explain. And anyway, the bill is in Parliament now. So if the NRF is going to offer any services, it must be to the committee. And they have offered these services by engaging regularly. So, I think we've gone very far with engaging with civil society. I'm not sure what more they expect of us. What more you expect of us? Frank, unless there's something we should be doing that we're not doing, you can advise me offline if you like. I don't know that we can take it any further with them. And if we spent another 6 months here, I'm sure not most, but, well, many of the issues, they're ideological, some of these issues. They are related to material interests of people consciously or unconsciously. They're related to notions of what transformation is. They're related to issues about the capacity of the state. Yes, somebody raised that. I think in our report we should say we express serious concern about the capacity of National Treasury to do these things. There is no phased. I've tried, by the way, Frank, maybe you know the story, but you know the story, but not the experience. I've tried. When Flemi Jinwala was speaker, we raised it, some of us, that you know what? You don't just put financial implications of a bill, you put down a capacity to implement and even the elements of a program to implement. You might recall, I've said this before to our committee members, with the Child Justice Act, we refused to process the bill. We said, we don't think, we told the Department of Justice, hey, we don't think you can do it. So we delayed it for 3 months or something until they came with a program. And even then, by the way, colleagues, they weren't able to implement that. So I don't have any illusions in the capacity of the state. But on the other hand, I don't think it's a failed state. They can do these things. The matter is of phasing it and so on. We would like, let's tell you now, we'd like you to give us the elements of your program. And you've got some time to do it. Well, this will come towards, not next Tuesday, the following week and so on. So nothing stops the stakeholders. These are open meetings. They're free to observe, but we now have to move into the committee stage for next Tuesday. Right. Can we get responses from members? Frank Jenkins first, of course. Sorry. Frank, please go ahead. And answer that question. Do you want to convene a workshop? Or do you want to just give us your legal opinion? It's your call.
I'm better with legal opinions than workshops. Chairperson, I can participate in a workshop, but I'm not going to organize it. And I need mandates for that. And I'm really quite occupied in my office. But if it needs to be done, I can participate, Chairperson. I've got just 2 issues I want to address.
Frank, if it needs to be done, it can only be done by Parliament now. We've given Treasury and the stakeholders. So the colleagues from the civil society need to know. And they're experts. Some of them are lawyers. It's now in our hands.
Yeah.
Better or for worse. And there's an election coming up, and they can also make their choices about the way we respond to this bill on that matter. So when I'm talking about a workshop, I'm asking you whether legal services unit feels the need for it. Do you have the capacity? And I get what you're saying. If you change your mind, you ring me offline and we'll sort it out. But for now, there's going to be no workshop, right? And we've been clear, right? Now, what we want from you is what we asked. Can you deliver that by Tuesday?
Yes, Chair. I've looked through National Treasury's issues. I've looked through the constitutional issues. I personally do not have much to add to the legal opinion and how they address various issues, even the issues of cooperative government, as well as the division of duties between the public procurement officer, provincial treasuries, national treasuries. I haven't found anything of concern, constitutional concern there, Chair. What I do need to address the committee on two things, Chair. One is the issue of unfunded mandates. It is a bit of a chicken and an egg situation as well, Chair, because if you recall, when we receive a annual performance plan or a annual report, strategic plan of a department, usually there's a chapter in there of all the applicable legislation that department needs to implement. And the budget will then also flow from those duties of implementing that legislation. So legislation that's not operative is not always getting a budget. So sometimes the budget will follow legislation coming into effect, and other times maybe the coordination will be a bit tighter or better. But passing legislation results in budget allocation, Chairperson, because there's an issue of legal compliance which cannot be circumvented in an annual performance plan. So I'm probably just confusing more than providing clarity there, Chair. I hope not. But the issue of a memorandum to the bill setting out financial obligations, and yes, it is a bit passing or kicking for touch when a department says there's no financial implications when there's tribunals being established and so forth. But it's definitely not an accurate issue, and there's usually what's called a socio-economic impact assessment that Department of Planning and Monitoring in the Presidency does, and I think stakeholders and National Treasury have access to that. The committee can also have access to that. That explains a little bit more what will happen when this bill is implemented, Chair. I haven't seen it for this bill, but it's a cabinet requirement. It's not a rules parliament requirement for department to give us that so-called CS, the socio-economic impact assessment on legislation. Chair, so that's the one area. The other area is just the role of Parliament and provincial legislatures in this bill. Chair, when the Public Finance Management Act was passed in 1999, already at that stage there was a recognition of the constitutional principle of separation of powers, and that's the crux around this specific issue that was raised by stakeholders. So the Public Finance Management Act says it only applies in a very limited respect to provincial legislatures and to Parliament because of the issue of separation of powers. And that was then giving a bit more effect to by Parliament itself when it passed the Financial Management of Parliament Act in 2009. There was a court case of Limpopo Premier, then Treasury refers to that in the documents as well, said that provinces can't provide for their own financial management. It's a national competency. So we included the provincial legislatures within the Financial Management of Parliament and Provincial Legislatures Act then. And we removed all references in the Public Finance Management Act to the provincial legislatures and to Parliament. So, Chair, when we're looking at the Public Procurement Bill before us, what Chapter 4 is doing is basically fulfilling the place of the Preferential Procurement Policy Framework Act. So Chapter 4 sets the preferential policy framework there for Parliament and provincial legislatures, much like the previous that Act did, which will be repealed once the Public Procurement Bill becomes an Act. So, Chair, the first point I want to make is that the Public Procurement Bill, as it becomes an Act, cannot apply wholesale to Parliament. Parliament and provincial legislatures, because of the separation of powers doctrine in the Constitution, which was recognized by the Constitutional Court already back in the certification judgment. Because of that principle, Chairperson, Parliament is entitled constitutionally to provide and to determine its own internal arrangements and proceedings. It's also empowered to provide for its own financial management, including supply chain management. But that in our Financial Management of Parliament and Provincial Legislatures Act says that it must comply with the framework in the Preferential Procurement Policy Framework Act. So, in other words, that will change to our Parliament's supply chain management policy, regulations, in fact. It's not policy, but it's regulations. Parliament must actually do its own preferential procurement according to regulations that must be published. That needs to comply with Chapter 4, and we need Chapter 4 for that, Chairperson. But it can't be that, for instance, Chapter 5 of the bill also applies to Parliament. That would intrude in Parliament's constitutional area, and it would be actually unconstitutional. So regardless of the challenges such a separation creates, it's something that we must blame on the ancient wisdom of people who created the separation of powers. I think it's a French principle that was taken over by the Americans when they did their 4th of July. So, Chairperson, where we are today, I don't see that as a constitutional concern. It's an issue, but it's not a concern. So for that, for now, Chair, that's my input. I will look at the other issues, and I will be here on Tuesday when we meet if there are more questions. Thank you, Chair. Chair, last thing, the issue of the bill, the Public Procurement Bill, not serving before the the Standing Committee and the National Assembly, Chair, is not correct. The Standing Committee on Finance did look at a draft bill that was prepared for it. It did not have the ISBN numbers on, but that bill was then carbon copied into the formal B version of the bill, which was before the National Assembly. But the Standing Committee did have a draft final bill. It had the final bill before it when it adopted its report and that bill. And according to me, Chair, I was there.
I've never heard of a committee not seeing a final draft in some or other form. Okay, now, Treasury, can you please reply to the issues raised briefly? I want to say something also before you do. So one of the stakeholders mentioned a 300-page plus report. I'm not sure what he expected as a reply, and maybe another 300 pages in reply. That would be unfair, unreasonable, really, because those 300 pages, Busa gave 150-page one, etc. here, and so on and so on. And if you look at all these stakeholders, you have hundreds of pages. You also postponed, and we agreed on the minister's request, not because the minister requested, because it seemed reasonable, to postpone our meeting for a week because you had to brief the provinces. And there's many, many submissions that you had to go through there too. So I don't think this committee feels badly, but if you've got the time, some stage you can reply to the stakeholder concerned, even if it's after, Parliament rises. I just thought I should say that because I think you've done a lot of work, Treasury. I'm not a big fan of yours when it comes to policy issues, as you know, but on work ethic, and as I've said, you were far more conciliatory overall, unless there are things we don't see, Willie. You're not politicians, not in the sense that we politicians, but you've also got your biases and so on. But I think you'll have done very good work. And you're far more conciliatory, it appears here several times in my notes, than I imagined you would be. And something seemed very straightforward to me, but let me be careful about what I say at this stage, that we don't need endless discussion. Now, Frank, on the issue you've just mentioned, I'm very clear about that latter part, about the separation of powers issue. We're not going to cover that endlessly, colleagues. Members of this Parliament also can take a bill to court, right, if they want, from different parties. So I don't think we need to endlessly engage on what Frank said. It's very clear to me. The co-chair of the Financial Management of Parliament committee is right here in our committee anyway, although she's not feeling great, as she explained, but we're grateful that she's here. Okay. I also want to say on the price thing, I'm glad it's being inserted very quickly, but let's see how you're doing it. On the applicability of Parliament, I've said that's straightforward. You've covered that. On the overlaps between chapter 4 and 5, I want to look at that more carefully. On whistleblowers, colleagues, can we think about this? We agree. You can be very strong in our report. And we're asking you, Treasury, maybe to do a cross-reference to the Protected Public Disclosures Act and the bill that's coming, right? But that's not something we can do here. I don't know what people are wanting, Frank. Can you advise us on those sort of issues? We agree. We can put a very strong provision in the courts, in our report. I have in 2 structures that I serve and raised this thing several times about the shocking failure of the state to protect decent, innocent people. And for all its blabbering, the private sector won't even employ these people. Other sectors, oh no, we can't take that person, is not kosher. So, I personally feel very strongly. I've raised it in various, 2 forums at least. I've raised it every now and then with, the people that are decision makers at the top. And, on that issue, we are very clear as a committee. Nobody's going to disagree. But the demand that it be inserted here, because it's going to take a while for the bill to come from justice, I think is not reasonable. Colleagues, just think about it. Can we also review that quickly? Those are like the quick ones, the ones that we can easily dismiss. I don't know if I can have the time, but I'll draw up a list, about 4 or 5 issues that are straightforward, really. Frank, can we go ahead and do something like being asked to do on whistleblowers? How would we do it? How would we preempt? There's already an act. We can always cross-reference to that act. If it's inadequate in our report, we say. Frank, will you think about it? Don't answer now necessarily.
Yeah, I'll think about it.
And I was going to say, despite your initial replies, we still want you to go through everything that you have gone through again, please. And on Tuesday, you will be the first person to speak and say, look, on reflection, I said this on Tuesday. What is it today? Yeah. But you know what? On Wednesday, and I thought about it. I think I'll give you a more nuanced, careful response. So please don't not do what we requested you to do. You went several steps ahead of what we expected. Okay, Treasury, over to you.
Yeah, thank you, Chair. And thank you very much. I'm not going to say a lot, but over and above what you've said and what
I can ask you, Willie, I've just noticed the advocate saying, what about part implementation of the bill? Is another option. Just to alert you, MP, we have done that. I think the municipal systems bill or what, where we said that the minister will regulate different parts of the bill to come into effect at different times. I think MP, other bills have had that. That's another option. Thank you, advocate. But I'm not saying we do it. I'm throwing a whole lot of possibilities. Okay, over to you, Willie.
Yeah. Thank you, Chair. No, much appreciated. I think your summary is spot on. I'm not even going to go there or even try to say what Advocate Jenkins has just said now. But safe to at least, Chair, say that the text of the bill is, based on our, recommendations in terms of where we should amend and so on. I think that's what we will have to produce and then submit to the committee based on those comments. And I'm sure there will be further engagements, of course, in the committee discussions. So that's one part. The second part that I want to at least assure, and we've been saying this repeatedly, around the fact that the regulations this time, unlike the norm, will be, of course, consulted with, the public, including our commitment that we made. Regulations will also be availed for discussion at NETLEG. And I think I still want to confirm that, and it should be on
Thanks.
record as well.
That helps. I was going to ask that. Good. Very good, Willie. Very good.
Yeah, we're going to take that back to it. And then equally, Chair, what we also said, even the instructions that the Treasury currently issues from time to time, we also agreed. I think we make a provision in the bill that at least instructions would also be gazetted for the public to comment on them before.
Good. Very good. Very good. Very good.
In the spirit of transparency before we have this. And of course, Chair, I think the other issues I'm not even going to respond to them, but let me respond to this one around issues that pertain to transformation and the report that we submitted to the committee. You know, sitting where I sit, Chair, and if I were to be asked by Black people to say, show us the 588 billion that we've been awarded, it's going to be very difficult for me to answer the question. Now, our explanation is in that regard is that remember that the measurement of the BEE is based on the broad-based nature of the BEE Act. So, in other words, what we say, there are many instances where I'll simply say this directly, where big business would normally ignore the ownership element of the scorecard, but at least prioritize the other elements of the scorecard, and then obtain a status level 1 or 2 and so on. So that issue is an issue that we've been talking about, to say you would still find the fact that it's a broad-based nature of the BEE Act, and therefore the fact that the 588 billion went to Black people may not necessarily be Black people. I want to underline Black people may not necessarily be correct. Hence, we say it may go to even a company that has, simply decides to ignore or embrace the ownership element of the BEE. That's the point that we're trying to make, Chair. Then the last part that I want to talk to, of course, if you look at the current system, the PPPFA, it has those two, preference point systems, the 80-20 and the 90-10. And I think the point is made that in your contracts which are more than 50 million, you apply the 90-10, which of course accords to 11.1% maximum. That's a fact. But what we are saying here, because we don't have a formula here in this bill, and that formula, so we can't say the percentage in terms of the premium, what that premium would be. But we have said to stakeholders, and also in our public comments, that we are then moving the issues of the formula to be prescribed through regulations by the minister. And the public, of course, will also have a comment in that particular issue to say what is affordable by the state and so on. And then we'll agree at the end of the day. Now, over the years, Chair, since the enactment of the PPPFA, Blacks have always been saying, but the inclusion of the preference point system formula in the primary legislation is the problem. And that's exactly what results in people complaining and say the PPPFA does not go far enough to address issues of transformation. Now we are saying we can't repeat that mistake and include in Chapter 4 or any part of the bill a formula of how the premiums and how evaluation will be conducted. But to us, this is more a subject of regulations, and we'll engage, of course, with all stakeholders stakeholders when it comes to that part. I thought I must just make that part, Chair, and because it's quite important in terms of transformation. The other issues, of course, are issues that we can always deal with. And in one of the clause 64.
Billy,
Yes, Chair, thank you.
12:47. No, hang on. And if we have to spill over 1 o'clock, fine. But there were specific questions put to you by civil society stakeholders. And in fairness,
yes,
you have to reply specifically to them. And if you can't find the answers now, that's understandable. You can write and give it to us and we'll forward it to them. So those specific questions, please remember to answer them.
All right. No, great. Then I'm going to run through the specific questions now. The issue around the strategic versus operational issues that was, of course, raised by Busa. We note that issue. And in our view, Chair, there's Chapter 5 does makes provision to a strategic approach, not only to what we would want to believe are strategic issues in the bill, but there is a provision. Because what we've been saying, Chair, if you take the sector, I'm just repeating myself, we take education, for instance, as a sector. And education will say to you, for us, LTSM, which is learner teacher support material, is quite critical. Even if you look at it as a pens and pencils or textbooks, but at the end of the day, for that sector, the procurement thereof should be strategic in nature. That's basically what we're saying. And hence, we've provided the clause in Chapter 25, which we believe is, a comprehensive clause that will look at those issues. Further to that, in clause 64, we also make a specific, reference to the procurement of infrastructure and capital assets, that the approach there should be strategic and the details thereof will come in the form of regulations. In the bill, we're making this enabling provision, but the bill will, of course, get into detail on what we mean, because infrastructure in itself is wide as a sector. You've got rail, road, and electricity, bulk water, ICT, and so on. Hence, we want to deal with each one of the individual infrastructure sectors as far as infrastructure is concerned. Now, the one other issue, Chair, by NRF around standstill, to say there would be a potential loss of the donor funds if we talk to standstill. And I think it was raised by NRF as well as Willpower. Look, what we're saying, even now in the current budgetary process, this is not a defense. We know that some government departments do not spend, they underspend. And at the end of the day, they lose that money. It goes back to the National Revenue Fund. So equally, if you're linking standstill to the issue around the loss of potential donors, I think that fact you can always counter with the fact that in any event, government departments do it. But further, Chair, in addition, why we have a standstill, it's because we have introduced the tribunal as a mechanism to deal with some disputes. And it's important and also to make sure that this government is not litigated against, whilst an aggrieved bidder has taken its matter back to the department for reconsideration or even to the tribunal. So hence we're saying the standstill is there, but what we've made a provision for exemption to say if there's any procurement that is urgent that will potentially have an impact on service delivery, at least there is an emergency provision that can always be invoked in those instances. So I thought that's just the part that I'm talking about. And the donor funding, Chair, at the Treasury currently we have a unit that specifically manages donor funds. And hence we are saying donors must also comply with this bill. because we don't want to create a, like, you know, we spoke about fragmentation in the system. So we're not going to have one system for donors that come from all over the world, and all of them wanted to impose their procurement prescripts on South Africa. We must have one rule for all donors, and if we need to apply at least exemption, let us do so. But it can't be free for all. Anyone getting donors, and then they impose and say, for you to take this donation, you then need to follow my procurement rules. We can't work that way. At least we need to regulate that part.
Good.
The other part, Chair, of course, will deal with the issues around specialists in a bid committees. That's fine. And I think we understand that part to say the bid committees must be cross-functional in nature. In other words, they must contain a different expertise, because you're dealing with all sorts of kinds of procurements in the country. And therefore, you need at least a variety of expertise when you're sitting in a bid committee system. But that's something that we say we'll also look at when we look at I think clause 29 of the bill. That's what we'll do. I think I've addressed the issue around standstill, Chair. Then the other issue I've dealt with this issue of the transformation that's specifically around the BE. And then I've also indicated that at least we will now work on the text of the bill based on our recommendations and the clauses that we're making, and then we'll make that available to the committee for consideration.
Yeah, but don't rush it, please, because there's quite a lot to do, right? So we're not saying you bring that on Tuesday, because you know how this committee works. At least MP will know. We first deal with policy issues, then we come to clause by clause. That's going to take a while when we come to clause by clause, right? We first look at the policy issues. Yeah, thanks.
Yeah, and then, Chair, around this 300-page submission that was made. I mean, I'm looking at the bill. The bill itself is about 37 pages. Now you have a submission which is 333 pages. And we need to look at it. I'm sure we'll look at that, but over time. But given the time constraints that we have, and also our roadshows in ordinary public participation sessions that we had around the country in various provinces, it was not possible for us to read 333-page submission, which must then inform a 37-page bill that is currently before the committee. I think it's a bit difficult for us to do so, but over time we'll look at the issues that are provided in that submission, including other submissions, JSR and so on, as we committed even during the NETLE process, and see, you know, to what extent do those submissions inform the regulations going forward? And we'll do that. We'll read that and see to what extent do those inform. But it's highly unlikely that a 300-page document would find expression in the bill, Chair. You know, no matter what way you look at this, it's quite impractical. Then, Chair, the issue around the definition of military veterans, I think that's something that we need to look at. We've heard that that part, and then also around data privacy. We also did make at least a comment in the early opening of this meeting, Chair, to say we may not have covered everything in the presentation, but at least we implore the committee and stakeholders to read the report that we submitted, because some of the issues are addressed in the report. I know that, for instance, in the case of the military, veterans, there was also a comment around excluding certain, people from submitting tenders because of the sensitive nature of the area that they operate in and so on. But some of these issues, Chair, are covered in there. I think, Chair, I'm not so sure if I missed out anything, but I'm sure my colleagues here will remind me if there's anything. The issues around Parliament and legislatures has already been cleared.
Yeah,
It's
thanks. Let's
addressed.
move on from there.
Yeah. But thank you very much, Chair. And I think you made a very important, Chair, comment around the fact that even if we were to sit here for 6 months or 12 months and say we want to get it, we're still going to have areas where we agree and we disagree. And thank you very much, Chair. I'm sure the advocate will add whatever she wants to add. Thank you.
Okay, Advocate Impey.
I'll be brief. Just on, I think one of the NRF, and it was also other stakeholders, asked about defining the terms in 2171, cost effective, etc. Our view, those terms should take, the ordinary definition and obviously how it's, dealt with in the bill and in the regulations, but to include definitions of those in our view would not be appropriate. Then just on the phased implementation of the bill, clause 68 provides for the president to bring into operation by proclamation and further indicates that the proclamation may determine different dates and also different dates for different categories of institutions and also possibly different types of procurement. So there is an enabling provision.
Yeah, it's there, yeah. Okay.
And that's all.
Okay. Thank you, colleagues. We are at the end. I want to take this opportunity once again to thank the stakeholders. I know you also put a lot of work in. You've written voluminously. I don't know how to pronounce the word. I think you're on a lot, okay? And I like what you said, Willie. I hope you're going to be held to account for it. Maybe we should put in the report, Esther, that they said they would look more carefully or look further or look again, or whatever the word is. Esther, you'll find it, or the committee will together, at the regulations, at the submissions when they're shaping regulations. Edging towards saying that Gabriel wants to ask a specific question. It can be done in writing the answer, but what is it now? With your indulgence, ask the specific, it seems to have slipped through the cracks. Does the phrase national legislation in section 35 include? Yeah, okay, that's a fair question. Can you answer that? That is a legal question, MP. Do you see it on the chat group? On the chat?
Yes, Jay, he did ask it in his input. In my view, the reading of that section, it refers to bills tabled in Parliament, and not to anything else. Because national legislation is not defined in the PFMA, but I think I understand why he's going, because he may ask if we table regulations in Parliament, as part of, do we also have to provide the funding implications for provinces?
Yes, yeah. Okay, I get it. Okay, thank you. Excuse me, yeah. So basically that's it. Now I want to remind members that Poppy Ntaka spent a lot of time drawing up for Parliament. We saw National Treasury, a breakdown on where BEE or BBBEES got. That report, Willie, in Nkululeko, can you send it out, please? And we will table it for consideration on Tuesday also, because that work was done and it can't just collect dust, as it were. So we're going to look at that as well on Tuesday. We know the procedure henceforth in the sense of the broad outlines, and then let's see where we get on Tuesday and collectively discuss a way forward. In the meanwhile, we will send you the program. Nkululeko sent it to me this morning for the period ahead. You must remember, colleagues, I don't know who makes these decisions, but it changes sometimes dramatically. No plenaries, and suddenly there is a plenary. Yes, there's a plenary. No, you don't reply to Cape Town. As far as I know, as far as we know, Nkululeko and I, the next sitting of the plenary is the 25th, which means we can sit all day next week, Tuesday, in the morning and in the afternoon, and so on. We can discuss that, but we will bring you a draft program, and you can reply by email. I know the election campaign is taking up a lot of our time, especially in a province like mine for my party. So, we're taking that into consideration too. Okay, thanks very much.